Okay, Alex, is everyone in the room ready there?
Yes, sir.
Okay, great. Kim, you ready to go? Great, thank you. All right, everybody, thanks for your patience. We'll go on the record. Thanks for tuning in to part 10 of the conditional use hearing before Churchill Borough Council on the application filed by Churchill Creek Project LLC to redevelop the former Westinghouse Research and Development Site at 1310 Beulah Road as a distribution center. As folks will recall, we ended the hearing with Mr. Balkey had just completed his testimony on behalf of the Tree Committee. Tonight, the plan is to finish up with Mr. Balkey if there's any cross-examination questions. Not sure if there will be. And once we complete Mr. Balkey, we will move on to presentation by the borough engineer. So before we get into all that, can you go ahead and swear those folks in, just in case we have some individuals who may not have been previously sworn?
For anyone that's not been sworn in yet, you can raise your hand, please. Your right hand. I'll swear you in. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thanks, Kim. And I do want to point out right now, you heard me mention before we went on the record that we are waiting on a councilman. Mr. Dwarn is en route. And I just want to point out for the record, and Alex can correct me if I'm wrong, but I do believe we've had a full contingent of council members throughout the hearing to date. We will make a point, as we just now, to note when a council member is absent. We've generally had 4 council members live in council chambers, as the remaining council members in the either in council chamber or participating remotely via Zoom. So with that said, I think we can go ahead. Alex, any other housekeeping that you could think of at this point? Okay.
Yeah.
Go ahead, Mr. Completed your task on behalf of the.
You're breaking up. Can't hear.
Gavin, you're breaking up quite a bit. This is Kim. I thought it was me at first, but you keep breaking up.
The record here is this. I don't think that's any better. Is it? I'm still breaking up, or am I okay? Alex, Kim.
You were breaking up. If you have another device on in your room, make sure only one device is on volume.
Yeah, I don't.
Okay.
Sorry, everybody. Just give me a minute to try to work through this. You think after 40 hours I'd have this nailed down, but just give me another moment here. All right, is that any better? So far, so good. I'll keep testing.
Yes.
Okay, all right. Well, hopefully whatever I did will continue to work for a little bit. Let's try to get going then with Mr. Balkey. Kim, let's go back on the record. And I think as I was saying before I broke up there, that Mr. Balkey had just completed his testimony on behalf of the tree committee. And we were going to turn it over for cross-examination by Mr. Gallagher and Mr. Metz first to see if there are any questions.
Just a few.
Go
Hey,
ahead.
good evening. We're good? Okay.
I think Ken is trying to say something.
I was trying to ask a question. Mr. Rob,
Go ahead, Mr. Balkey.
you know, I worked to get the presentation to finish right at 11 o'clock. And I have one piece of supplemental information. I don't know if I'm permitted to do that now before I start cross-examination.
Yeah, I think Mr. Balkey, speak now or forever hold your peace. Why don't you go ahead and present what you need to present, then we'll turn it over to Mr. Gallagher.
Okay. I raised the point in our presentation, we've raised the point of the water distribution or rainfall distribution estimates in the stormwater work. And we raised concerns that it may not be picking up recent severe storms have occurred, particularly Hurricane Ivan. So here it works out when you go back to the data that supports the applicant's work. There was a reference to a point of contact to ask about the data at the National Oceanic Atmospheric Administration, or NOAA. The National Weather Service is part of that. And we asked them about how far the data was and did they have any intention of updating it for these climate change events. It works out, so we've heard back from Sandra Pavlovic. She's a professional engineer in the Office of Water Prediction at the National Weather Center in Maryland. And she said that the data for Pennsylvania only goes through December of 2000. And they know that they need to update the data and they would like to, but they don't have the funding to do it. There's a bill in Congress now for them to do it. And some states have, two have provided funding where they've brought the data up to 2021. There's 5 more in the hopper. So, and they also ran their models for the hurricane or tropical depression Ida that just struck, and also the big storm that hit Tennessee that I discussed. And of course, it shows that those events were way outside the 2 to 100 year realm. So the key point is that we raised the question of the data relative to today, and we were able to get from the official source that it was for the year 2000, or for the year 2000. Thank you.
Thanks, Mr. Balkey. Mr. Gallagher, your questions, please.
Yeah, thank you, Mr. Rob. Good evening, Mr. Balkey. How are you doing?
Very good, thank you.
I was reviewing your web bio for your mechanical engineering alumni webpage. It's very impressive, I have to say.
Oh, thank you.
Can you still run a sub 5-minute mile?
No, those days are long gone, but I am running in my 44th great race on Sunday, God willing.
Oh, good. That's good to hear. So I see you graduated in '72 with a degree in mechanical engineering, and you have a master's degree in mechanical engineering as well, correct?
Yes.
Okay. And then you worked for was it 42 years for Westinghouse as a mechanical engineer?
That's correct.
Okay. And you retired in 2014?
just from Westinghouse.
Okay. Are you a certified arborist?
No, I'm not, but I have worked with arborists and been working side by side with them ever since we started the tree work 3 years ago. And if,
I have no further.
go ahead.
No, I'm sorry. Go ahead. You can finish your answer. I didn't mean to cut
I was
you
going to
off.
say that, yes, and as I mentioned during our presentation, our committee has worked with 3 arborists from 3 different vantage points. Jason Ryan of Bartlett has helped our tree committee dealing with tree diseases and tree pruning that are done throughout the borough. And then the other person is Jake Malofsky from Tree Pittsburgh, and he has actually surveyed all of our public spaces, including the Churchill Greenway. It's belongs to the Allegheny Land Trust, and he's helping us and the school district with tree planting events. And then finally, Vince Catrone at Penn State Extension has been running webinars for tree committees across the Commonwealth with the Department of Forestry and Department of Environmental Protection, discussing stormwater and other concerns dealing with tree populations in our various communities. So that's where we've got our information, having a chance to work with those folks. It's been a great learning experience.
That's good to hear. So, thank you. I have no further questions.
Okay, are there any other questions for Mr. Balkey? Mr. Ferguson, I'll give you the first crack.
Yes, thank you. Mr. Balkey, do you know what it requires to become a certified arborist, or who certifies arborists?
Well, I know who certifies them. It's the International Society of Arborists. So you see the acronym ISA, but next to the person's name.
Okay.
And I do not have all their full requirements. Whether it's education, how many years of practice, but there's the webinars and the events that I've attended where I get professional development hours for my professional engineering license. The arborists get the equivalent continuing education units that they apply for theirs. So I would expect it to be similar to what I have to do to maintain my professional engineering license.
Okay. And are you aware that there's an exam that if you successfully complete it, you may become a certified arborist?
I was not aware of that, and that's consistent with the professional engineering exam that I had to take. Okay.
And were you aware that to be a certified arborist, you need 3 years of experience?
Okay, and that's similar in our case, the professional engineers, we need 4.
Okay, so tell us about your 3 years of experience.
Since starting the tree committee?
Yes.
Yeah, it started out dealing with, there were residents starting to cut trees down along the rights of way, and we knew from having friends in other boroughs that other boroughs prohibited that. We raised the concern to the borough officials. And the reason I'm giving you that little bit of background, when we wrote, my wife Ruth Ann and I wrote the letter raising the concern, we had no idea, and she works with me, even though her name's not on the committee. My wife Ruth Ann does a tremendous amount of work along with me. We had no idea what we were venturing into. Because shortly when we went to get our ordinance passed in 2019, it just so happened that Tree Pittsburgh, it started issuing tree canopy maps. And in fact, the arborist for, it wasn't Jake Malofsky, it was Matt Erb, another arborist. He spent the weekend making a tree canopy map for us. And we started realizing how fast we were losing trees across the borough, some along the rights of way, a lot of them on private property. And so as we've gone along, it's been a tremendous education effort to understand the impact of the trees on our community from both an environmental and economic standpoint. And the more we get involved, there's just so much more to learn and to gather on this space. and having the chance to interface with my counterparts who lead the other tree committees of other municipalities has been invaluable in terms of sharing experiences. So to make a short summary, it's been a steep learning curve.
And for purposes of this hearing, you haven't purported to identify tree species, diagnose tree diseases, recommend treatment for trees, or anything of that nature, have you?
We've just started in, well, we have 2 cases.
I'm talking about for purposes of this hearing and the testimony that you rendered, you weren't proposing to discuss tree species or diagnose diseases or perform those functions of an arborist.
When, for the hearings, I want to be careful here because the hearing started on July 19th. Prior to the hearings, the applicant had been meeting on a regular basis with the Planning Commission for the borough. And from the aspect of no one had an estimate of the trees until our tree committee was permitted on the grounds by the current owner to look at the property, get a better close-up look feel, and we were able to do a rough estimate of how many trees were impacted by the proposed project. And we wrote a report in January that was submitted for distribution to all parties involved. Then the applicant brought in Walter Jarash, who, by the way, I've asked other arborists, he is spoken of very highly. So the arborist that came in and did the tree counting on behalf of the applicant, and then also cataloged all the trees, was of great interest to us because we had never done that anywhere else. And the arborist, with the help of others, provided a very comprehensive report on the state of the trees, particularly on the hillsides, the slopes, surrounding the property. And so with that background, then we updated our response. When we saw that, we provided a response back what the tree loss would be. And with that background, we entered then into the public hearings. So entering into the hearings on July 19th, we had reviewed the arborist work in great detail, updated our assessment of what that impact would be, and then prepared the presentation material that was shown last Monday in order to have a very well-educated discussion about the topic.
And what do you see to be the role of the Borough of Churchill Tree Committee with regard to advising council on the Hillwood application for the Westinghouse site?
The tree committee, our ordinance, has really 3 parts to it. Well, actually, there's A, B, and C, but part B is the goal of the tree committee is to advise the borough in the maintenance enhancement of the trees from an enforcement standpoint along the rights of way, public spaces, playgrounds, highways, and parks. But there's a second part to that, and as to we're establishing an educational program regarding the value of the trees to the community, its environment, and property values. And then any findings that we have, we're responsible to report to the Borough Council on a quarterly basis, which we do even during COVID here. And we've covered so for this particular property, our Borough Council, since we started the tree committee, even when it was in its pre-planning work and then formally put in place in June of 2019, we have been updating our borough, not just on trees along the rights of way in the parks. We've been advising on the Greenway project. We have provided advice for tree losses on private property and the concerns about our tree canopy slowly being reduced. So the role of our tree committee is trying, based on the background that we've gained by working with the arborists, working with folks like at Penn State Extension and the other tree committees, we're trying to provide what we know relative to the impact of the tree impact from the stormwater, health effects, other environmental effects, and economic. So the presentation my colleagues and I put together was really in the line of that second item B, which is educating both our Borough Council and our residents on the impact of this potential tree loss.
Thank you. So, and you did not appear in this public hearing because you were called to be a witness for the applicant Hillwood, did you?
No, I report to the Borough Council, our tree committee. We're appointed with terms by the Borough Council. I report to them, and I would only be here at the discretion of the Borough Council.
Okay, and just to be thorough, you did not appear here because I, as an advocate for some of the members of Churchill Future, asked you to appear and testify. Isn't that right?
That is correct. You did not ask me. Our history goes back before, I think, I don't have all the background on the residents working with you, but we have a report on file we wrote in January. It already expressed our concerns. Of course, that led to the applicant was kind enough to get an arborist and really catalog the trees, which, as I said, we really greatly appreciated the work that was done.
Okay.
But so we've been working independently of anyone else.
And if I recall correctly, and pardon the paraphrasing, I believe that Mr. Robb, who is both the hearing officer and solicitor for the Borough of Churchill, explained your testimony that that council, because it values the opinions of the tree committee, asked that the tree committee appear at this hearing in order to advise council as to the committee's observations and conclusions with regard to the impact of trees from this development. Is that your recollection?
That's correct.
Okay. So in light of that, as you may or may not know, council is evaluating the application against specific express criteria that appears in the zoning ordinance. I'd like to just, because these are very overlapping, if you'll pardon me, I'm going to just read for you requirements that are found in section 304-31.
Objection, this is irrelevant.
Oh, the
Sounds like-
criteria of the ordinance is now not relevant.
So, yeah, I'm not sure I follow that objection, Mr. Gallagher. I'm going to overrule that one. But, Mr. Ferguson, Mr. Balkey's testimony was, as long as you're going to keep your questions related to his tree testimony and not take us through unrelated portions of the ordinance, I think just for efficiency's sake, I'd appreciate that.
Yeah, for sure. All right, so I'm going to read D, E, and H consecutively. And those requirements are that the proposed use shall be sited, oriented, landscaped, and screened to produce a harmonious relationship of buildings and grounds to adjacent buildings and properties. That was D. E provides the proposed use shall produce a total visual impression and environment, which is consistent with the environment of the neighborhood. And H provides the proposed use shall be consistent with past development of the borough and its current character. And my question to you, on behalf of the tree committee, is the summary of your testimony that you rendered in hearing number 9, that the proposed removal and planting of trees as proposed by Hillwood will or will not achieve these objectives as set forth in the ordinance?
Our concern, our fundamental concern, are not the trees that are around. There's 100 trees around the buildings, and also there's trees where the parking lot would go. Our concern centers on the ones we showed in the photograph on the first slide, all the trees that are on the slopes on the west side, and particularly the trees over Beulah Road. And the concern is that removal of those trees, it's not just from an aesthetic standpoint. We have concerns dealing with stormwater runoff, particularly given my own experience, having been on the site with Hurricane Ivan in 2004. where huge streams of water came off that east face with the trees in place. And then also for the residents who are nearby, in the last 3 years with the information our tree committee has learned on the benefit of trees, taking those trees will impact the air quality of the people that live nearby. It'll impact the economic values of the homes that are there. So I know a lot of effort's been going to landscape the effort back, but our tree committee has just deep concerns about removing the mature trees because it'll take decades to get any trees up to come anything close to what's there. And the other thing, from an historical standpoint, I've seen photographs of that site that were there before Westinghouse was built. This is from the late 1930s, I believe. And those trees on the hillsides are there. So when Westinghouse built their facilities, they did not do anything to disturb those trees on those slopes. And so it's those trees. If the project would be revised such that it's not taking all those trees off those slopes, it would have a different consideration.
Okay. And Mr. Balkey, is it the view of the tree committee that Hillwood is utilizing what the tree committee would regard as an environmentally positive design?
As we indicated in our presentation last week, those trees from an environmental standpoint absorb significant tons of air pollution. And I mentioned on just CO2 alone, estimated it absorbs about 20 tons of CO2 throughout a year. And I know that other trees can be brought and replaced, but it'll take years till you would ever get back. And with the current environment we're all living in, not just here locally, but worldwide, it just seems like it would be very unwise to remove that and lose that benefit that our community contributes. And people forget too that each mature tree provides enough oxygen for about 4 people. So there's that benefit as well too. And I think we as a people, we're losing sight of that, of how important the trees are to our own livelihood.
And a prior witness, Mr. Victor, was recommending the reforestation of areas on the proposed built site. Even if Hillwood replaces trees on a 1-to-1 ratio, would this achieve the result that the tree committee would like to see?
Because of what we've learned working with Penn State Extension and also with all the other tree committees, we have to be very careful when you say 1 new tree equals 1 mature tree. And I tried to put a slide, we tried to have a slide that demonstrated that impact. So even though we appreciate all the effort to replant, reforest, we want to do everything we can to keep all the mature trees that we can, because it takes 50 or 60 or 70 years for them to get into that state. And so we really are challenged by saying you remove all those, hundreds and hundreds of mature trees, particularly off the slopes. There's really not much you can do it's gone. And you can reforest and do, but in most of our lifetimes, it won't be back. It'll never be back to what it was.
Thank you, Mr. Balkey. That's all the questions I have, Mr. Rob.
Thank you, Mr. Ferguson. And I'm going to apologize to the group in advance. I think I'm going to have to shut video off so I don't keep chopping up. So I am going to continue to speak here, but you just won't see me. So sorry for that. Are there any other questions for Mr. Balkey from any party objectors? If you do have questions, please raise your hand. Alex will recognize you. I see Dr. Sterrett. I'm going to keep the video on because it appears to be working right now. I see Dr. Sterrett may have a question or two for Mr. Balkey. So well, go ahead, Dr. Sterrett, and unmute yourself and ask your question.
Oh, hi, Ken.
Hello, Susan.
I can't see. There you go. Hi, yes. In your report, you mentioned a lot of health effects, and those do those are governed by the code. But I wanted to show you a part of the code and ask you whether a certain phrase in it applies to what you've talked about. And that is this phrase, existing stands of mature wet woodlands. So the code does say for zoning that existing stands of mature woodlands shall be developed so as to minimize adverse environmental effects, unnecessary grading and clearing. So I would think that, well, I wanted to ask you, are there existing stands of mature woodlands on the property that you're referring to in your report?
If you look at the diagrams that our committee provided, both ones that came off my phone, plus the nice diagram that Mr. Jarash provided in his tree survey, and then also the photograph, the aerial photograph we have. I'm very familiar, having had the chance to walk within those woodlands. You can't tell how extensive those trees are until you get up inside them. We see them from the distance, we see them from the right. I'm talking about all the trees all along and above Buell Road, all the trees on the west side that face over towards Greensburg Pike. And then of course, there's trees on the south side that to my understanding would be not disturbed, that folks from Lewin Lane may be visible to them or folks on Fenwick Drive. There was actually discussion years ago of Westinghouse was going to turn over a good bit of the property to turn into a park, but it didn't happen. And one of the discussions was to build trails through those woodlands on the east side, the south side, and possibly even on the west. The west side's is really steep. And when you get up underneath it, the trees, first of all, are much larger than what you believe they are, and they're much tighter than what you expect from down below. And when Dr. Kisloff and I toured the site back in January, I was actually really taken back by how forested those slopes are, and also the wildlife that I personally witnessed. And this was in January, that were within the trees itself too. So, and I'm very familiar with this 30427 as the environmental protection requirement. And that's really what we're addressing, is that removal of trees from those slopes can have very significant environmental impacts. And that's what we tried to show in the presentation last month.
Okay, so your answer is actually the code seems to say existing stands of mature woodlands anywhere. So your testimony is that the property does contain existing stands of mature woodlands that the current proposal would remove, and it does not minimize adverse environmental effects.
Yes, it would be. says to it, but that's the issue. It does not minimize the adverse environmental effects are significant with the loss. But the number one in our mind is the stormwater, because we know we've had serious events. Floodings occurred on Buell Road. Cars have got washed away off Buell Road further down. And to take those trees off, really, that's the number one. Then the second would be all the residents who live around the property, taking those woodlands, you're definitely going to reduce their air quality. Others have testified through the public hearings here about the air quality in our area, which there are high alert days that we have. But removing those trees, you're really going to reduce the air quality, particularly for people who live on Buell Road, Old Buell, Holland, or over on Greensburg Pike.
Yeah,
So,
okay. Whoops. So I understand. I'm just, that's all good. It's just that this part of the code doesn't really give a reason why. It just states, yeah, well, I guess, I see what you're saying. You're saying what the adverse environmental effects are. So thank you. Yes. Okay. Thank you. Vanessa, you wanted, if I interrupted you, please continue.
No, I'm
Okay, are there any other party objectors with questions for Mr. Balkey before we move on to the borough engineer? We'll give it about another couple minutes. Alex, anyone in the room, any council members with questions for Mr. Balkey? Or any council members online?
we have no one in the room who has a question. Do know that Sandy Fox had a question, and I wasn't sure if it was related to this or if it was in relation to who can speak when. And it may be just helpful to have Sandy's question at this break between one and the other so that it can be clarified moving forward. I think a lot of people have a similar question what Sandy has. So Sandy, why don't you go ahead and unmute yourself and ask your question so we can all hear it.
Okay, thank you, Alex. Obviously, my husband's name, Terry Shuko, is there, but it's really me. We share a computer. I got an email today from Anna Gonzalez, who's from Rialto, California, part of the Inland Empire. It's known as in Southern California, where there are Amazon warehouses and other warehouses. And she's on the call and would like to.
Objection, this is irrelevant. Her point.
Just hold on, Mr. Gallagher, hold on one second and let her finish her question, and then, we'll deal with the objection. Or I may just be able to answer her question.
Yeah, I'm asking if she can testify or give public comments. I know last week it was brought up that GASP had sent a letter and they thought they couldn't give public comments because they didn't have standing. And Gavin, I recall that you said they could have standing. She lives in a community that is that has an Amazon warehouse, that she could speak to the lived experience of that. And I understand that there is legal precedent for someone in a similar situation to have standing.
So here's my position on that the objectors cases are closed. Obviously there can be continued cross-examination depending on which witnesses come up. So when it comes to public comment, those are limited to residents and taxpayers only.
But I thought you said last week that GASP could have given public comments. They could have had standing.
What I said last week was no determinations regarding the admissibility or standing of any third parties in GASP was made off the record. So no presentation not appear before this council. I'm breaking up, huh?
Yeah, Gavin, I got bits and pieces of your testimony.
Gavin, go ahead and turn your camera off.
I said it real. Yeah, I sounded real smart too, Kim. So if you could just try to recreate that, that would be great.
Okay, no problem.
All right, so I apologize for that. Ms. Fox, I'm not sure where I lost you, but again, the position with respect to GASP was Mr. Ferguson had asked whether or not a determination as to standing for GASP or any of its members had been made outside of the hearing. I assured him that it had not, that I have had no communications with GASP. And GASP, had they presented a case and have been able to establish standing while the party objector cases were going on, I can't say whether or not they would have been able to establish standing, possibly by way of having a member who had standing. But party objector cases are over. This hearing started on July 19th. There's been plenty of time. We gave every opportunity for, frankly, we've listened to quite a bit of testimony and given plenty of time for people to have additional days even to prepare their testimony. So we specifically announced at the last hearing that we had moved on to the next phase after the party objector phase. And that was to hear from first the tree committee and then ultimately from hopefully the borough engineer tonight. We will then give the applicant an opportunity to present a rebuttal case if they so choose. Hopefully at the next hearing, if we get through the borough engineer tonight. And then after the rebuttal case, we will open the floor to residents and taxpayers of the borough to provide public comment prior to the close of the hearing.
Okay, while you were speaking, Gavin, I got 2 texts from Anna saying, one, I am a taxpayer who can speak on the impacts on public health. And her second one, and I'm familiar with standing up to Hillwood Corporation. That's very unfortunate.
Yeah, that does not change my determination, but I thank you for passing that along, and hopefully that answers your question, even if you don't agree.
Well, if I may, let me just interject here. So first, I don't specifically recall whether Ms. Schutko is an individual party objector or not.
I'm Sandy Fox.
I beg your pardon, just reading the screen.
I know, it's my husband's name.
Okay, so
I am an individual
He
objector.
is an individual. Okay. So, and I don't think that Ms. Cox had an opportunity to at least explain what the scope of the testimony would be from this other person. And I'm just saying that we don't actually know what the content of that proposed testimony was. However, I'm suggesting that I'm not sure what the testimony of the township engineer will be, as well as those engineers that have been engaged by the township engineer to present their various reports. I presume that the reports that were posted online will be generally the scope of the township engineer's testimony. And also we don't know if or what the scope of the applicant's redirect or rebuttal testimony may be, but I'm suggesting that I don't think that either we or an individual objector would be properly precluded from responding to that additional testimony from either the township engineer or from the applicant at the time.
So, Mr. Ferguson, I think you're sort of asking hypothetical. You're talking about hypotheticals. If you want to object for the record as to the determination I made with respect to Ms. Fox's request, we can certainly note that for the record. Otherwise, we'll deal with those other issues that you've raised when the time is appropriate.
Okay, and just to be clear, Mr. Robb, so, and I do understand that you've made, as the hearing officer, you've made a determination with regard to this current request. However, should an opportunity at a later time arise where she may wish to renew her request, you would rule on that at the time. Is that correct?
That's correct. And yes, since you do not represent Ms. Fox, I would expect her to assert that objection or that argument at that time. I know you're representing your clients, and I know you're trying to help out here, and we certainly appreciate that. But when that time comes, we will make that determination.
Okay. I mean, the question does go to my ability to bring any type of responsive testimony as well. And probably more importantly, there are 104 people now on this Zoom, on this call broadcast. And my concern is that it might be interpreted that there is absolutely no other opportunity for anyone else to present anything other than in public comment by taxpayers and citizens. And I'm just hoping that just by having this discussion, it would avoid that type of confusion.
Thank you for performing that public service, Mr. Ferguson. I think we can go ahead then and move on. We're finished with Mr. Balkey. Ms. Fox, yes?
Anna Gonzalez is asking if another taxpayer or resident from Churchill would be willing to yield their time in public comments if she could speak in that case.
No, that's not how that works, Ms. Fox. This individual must be a resident or taxpayer of the borough of Churchill in order to participate in public comment. All right, Mr. Balkey, it appears there's no further questions for you, so you are officially off the hot seat. Thank you very much for your testimony this evening. And again, as I mentioned before Mr. Balkey began his testimony, and you go ahead and mute yourself and shut off your camera there, or you leave your camera on if you like, but as I mentioned prior to beginning the tree committee testimony, it is a bit unusual for a conditional use hearing for borough consultants, for lack of a better term, or ad hoc committees or committees to present testimony. And that's similar to where we're going next with the borough engineer. The difference, I would say, in this particular case is it relates to the zoning ordinance itself, which does require in 37.1 of the zoning ordinance that all studies be submitted to the borough engineer for review and approval. So for that reason, again, the borough engineer will be presenting a report. I understand the borough engineer is represented by counsel tonight, so I'll let their counsel enter an appearance, and if there's any kind of introduction, we'll turn it over to him.
Thank you, Mr. Rob. Good evening, members of council. My name is Tom Ayob. I am new to these proceedings. I represent the Gateway Engineers, Inc. It is a little bit unusual that a borough engineer would be represented at a public hearing, but it is also, as you stated, unusual that the borough engineer would be asked to offer testimony in a conditional use proceeding. However, the Borough of Churchill Code, specifically Section 304, the zoning ordinance, and more specifically Section 304-37.1, requires the borough engineer to review and approve certain studies or reports submitted by an applicant. So for that reason, Gateway, to undertake its role as the borough engineer and as directed by the borough, Gateway's representative is here to offer testimony tonight. Now, you informed Gateway, Mr. Rob, that in your role as the borough solicitor, you are conducting the hearing tonight, and as such will not be able to offer any representation to Gateway, even though Gateway's involvement is solely and only in its capacity as the borough engineer. So because there are adverse parties in this proceeding that may cross-examine Gateway based upon the testimony that it will offer tonight, Gateway is asked that I represent them, or the representative from Gateway, to ensure, in my opinion, and in Gateway's proper treatment and proper questioning limited to its role as the borough engineer and specifically its role as enumerated in Section 304-37.1 of the zoning ordinance. With that as kind of an opening, Gateway will present Dennis Flynn to offer the testimony tonight. To the extent there are questions of Mr. Flynn that he himself cannot specifically answer, there are certain sub-consultants that Gateway has retained to assist in its effort with regard to this application. And there are other individuals in Gateway's office. They are all participating in the call this evening. And if need be, upon questioning, Mr. Flynn will be able to direct a question at the end of his testimony to the appropriate individual.
Yeah, I'm just gonna raise an objection to the testimony of the engineer. The code sections which were referred to don't speak of any necessity of calling the township engineer as witnesses in the conditional use proceeding. This is a quasi-judicial proceeding. The applicant hasn't called the engineer. No objector has called the engineer. And the township isn't separately represented for any particular purpose in connection with this. So that's the first thing. I don't understand whose witness the township engineer is or why they're being called.
Just a point of clarification, Mr. Ferguson. I apologize for interrupting. It is a borough. Just as a reminder, we're talking about a borough, and I think the answer to your question is derived directly from the ordinance itself, which does require that review and approval. So if that review and approval by the borough engineer, whether or not, they've already submitted reports, they've already been widely circulated. As you know, there was sort of a somewhat of an iterative process between the applicant and the borough engineer. That's all of record, I believe, the back and forth review and response letters on items such as traffic, lighting, noise, et cetera, including letters back and forth from the sub-consultants to the engineers, the applicant's engineer. So I think that it's relevant and fair to have that testimony and evidence of record, since it is critical to or a required conditional use criteria as part of the ordinance.
Well, I suppose then that if they were critical, then the applicant would move to make them part of the record. And somebody would actually, one of the parties to the action would actually ask to have the engineer testify with regard to that report, but no party for or against or even neutral has asked.
So you didn't have the same objection to the tree committee, though?
No, I didn't.
Okay. Well, I'm going to overrule the objection. Certainly we'll note it for the record, and we'll proceed with the borough engineer's testimony.
Okay, I also want to just be clear about the purpose of legal counsel for the witness, the engineer. There's no risk of invoking Fifth Amendment rights against incrimination here. I mean, and I think that if there's a question that seems to be improper to the borough engineer, then parties on one side or the other would raise that objection.
Mr. Ferguson, as I stated, or as Mr. Ayob stated, the borough did not request that Gateway retain separate counsel. Gateway's made a determination that they feel they need representation. And I, in my role as running this hearing, I'm not going to tell them they're not entitled to have a legal representative at this hearing.
Yeah, I'm not objecting to his presence. I just don't understand what the role is of a borough engineer's legal counsel. What possible risk could there be to the township engineer here that would be mitigated by their legal counsel? I mean,
and I'm not suggesting that there is any, Mr. Ferguson. I mean, I think they'll leave that between Mr. Ayob and his client. And like I said, why don't we go ahead and move forward with this testimony? Your objection is noted for the record.
thank you.
Sure.
Okay, thank you. Mr. Flynn, please state your full name.
Dennis James Flynn.
And how are you currently employed?
I am employed by the Gateway Engineer.
Please just generally provide your professional qualifications.
I've been working with Gateway since 2007, following graduation with a bachelor's degree in engineering, and I am a professional engineer registered in the state of Pennsylvania.
Is the Gateway Engineers, Inc. the borough engineer for the borough of Churchill?
Yes, we are.
And how long have you worked with Gateway for the borough of Churchill?
I've been working with the borough of Churchill for the majority of those 14 years as the primary contact, probably for about 8 years now.
You broke up, Mr. Flynn. I don't know if anybody heard that. Would you answer that question again?
Sure. I've been working with the borough of Churchill for the majority of those 14 years as the primary contact. I have been, that's been about 8 years now that I've been the primary contact for the borough of Churchill.
So you are currently the primary point person or contact for Gateway with the borough of Churchill?
That is correct, yes.
Are you familiar with the conditional use application filed by Churchill Creek Project LLC?
I am, yep.
Now, very redundant to say, but you understand that the sought after conditional use is a distribution center?
It is, yes.
Are you familiar with section 304-37.1 of the Borough of Churchill zoning ordinance?
I am, yes.
I call your attention to subsection B. of section 304-37.1. And I'll read it for you and for the benefit of everybody. It's short. It specifically says, the applicant shall provide a traffic study establishing that the traffic generated at the site will not have a material negative impact on the neighborhood, which study shall be subject to review and approval by the borough traffic engineer. The applicant shall make any improvements reasonably required to mitigate material impacts on traffic and traffic safety. Is the Gateway Engineers, Inc. the borough traffic engineer?
Yes, we are.
And did the applicant provide a traffic study?
Yes, they did.
And did Gateway review the traffic study?
We have, yes.
Are Gateway's review comments memorialized in the documents that were marked as Exhibit 4 in these proceedings?
Yes.
Did Gateway review proposed improvements by the applicant that were offered as reasonably required to mitigate material impacts on traffic and traffic safety?
Yes, we did review those improvements.
Now, if the applicant makes the proposed improvements, does the traffic study, in your opinion, establish that the traffic generated at the site will not have a material negative impact on the
Now, this is
neighborhood?
where I'm objecting. This is the decision for Borough Council. It's not for the engineer to render that opinion, nor does the code provide that.
And Mr. Ferguson, I will agree that Gateway cannot testify to the ultimate determination as to whether or not the application meets the code. However, I do think the Gateway can testify as to whether or not the traffic study or the proposed improvements meet the applicable engineering standards, or whether or not that, so in other words, if there is a negative material impact, that these proposed mitigations meet the relevant engineering standards. So they can't say, yes, the applicant meets section A or whatever section of the code, but I think they can provide the testimony that's essentially already been provided in their reports, which is whether or not the proposed mitigation, whether the study and the proposed mitigation is compliant with applicable standards. And I think that's it's different testimony.
I'll restate that question then. So if the applicant makes the proposed improvements, does the traffic study show that the traffic generated at the site will not have a material negative impact on the neighborhood?
It's the same question and the same objection.
I'll overrule the objection. Go ahead, Mr. Flynn.
Yes, it does.
Did Gateway approve the traffic study contingent on the proposed improvements being made?
Yes, we did.
I call your attention to subsection D of section 304-37.1. It reads, the applicant shall prepare a parking study subject to review and reasonable approval by the borough engineer, and shall ensure adequate parking as determined by the borough based on the approved parking study. Did the applicant provide a parking study?
They did.
Did Gateway review the parking study?
We have, yes.
Are Gateway's review comments memorialized in the documents that were marked as Exhibit 5 in these proceedings?
Yes.
Does the parking study show adequate parking at the subject property?
Yes, it does.
For this reason, did Gateway approve the parking study?
We have, yes.
I'm just going to raise the same objection. I think you're letting him testify to the ultimate issue in the matter. And I don't think it's the role. If he submitted a report, the report says what it says. But I think you're literally going down the ordinance and asking whether or not the evidence submitted by the applicant meets the criteria of the ordinance, which is the ultimate issue and is highly prejudicial.
Well, isn't Mr. Ferguson, isn't that what's contained in the written reports?
Well, there are, I believe there are 8 reports.
And ultimately, don't those reports come to a determination one way or the other from each of the gateway or sub-consultants?
No, they don't.
Okay.
There are 8 reports, and a number of them indicate that there are either non-compliance with the engineer's requirements or matters which cannot currently be determined, but which should be examined post-construction. So no, they don't, all these reports don't say that, yes, there's compliance.
Well, I think, Mr. Ferguson, you'll be entitled to ask that question on cross-examination to establish whether or not this testimony is credible or not.
I understand, but it's a separate objection to allow this witness to go through and testify as to the ultimate issues in the case. So I won't keep raising it, but that's a continuing objection if we're going down this line of question. I believe you already sustained it once. I'm not sure why, I even raised it again.
Well, Mr. Ferguson, I just to streamline things, we will note a continuing objection on this line of questioning, and then we'll just go ahead and keep things moving here.
So let me be clear, Mr. Robb, in light of the dialogue back and forth between you and Mr. Ferguson. Gateway is not offering a conclusion as to the ultimate issue of law or fact regarding the underlying application. With regard to a zoning ordinance that requires a borough engineer to review and approve a report as showing something, Gateway is simply acknowledging the receipt and review of a report and identifying that it does state some conclusion, the report, not Gateway's conclusion, as set forth in the documents that are marked as exhibits. So Gateway is not offering testimony for or against the proposed application or development, and it's not offering opinion beyond the specific testimony of the limited scope as required by the zoning code.
That's consistent with my understanding, Mr. Ayob. And
Okay.
I understand, Mr. Ferguson, I'm not asking you to agree with that. You certainly, again, we've noted your objection, and let's move on to the next question.
Okay. Mr. Flynn, I call your attention to subsection E of section 304-37.1. It reads, the applicant shall provide a lighting study establishing that the light generated by the distribution center will either 1, comply with the criteria set forth in section 304-17, 2, not have a material negative impact on surrounding residential properties, or 3, that the potential material detrimental impacts to surrounding residential properties will be sufficiently mitigated by screening, buffers, barriers, or other means. I also want to call your attention to section 304-17. It reads, and that's the section referenced in 304-37.1E. And it says, exterior lights where provided shall be so placed and shielded to ensure that no light shines directly on any adjacent residential property, that reflected glare shall not exceed 0.25 foot candle when measured on any adjacent property, and no light shall diminish the visibility of vehicular traffic. Exterior light standards shall not exceed a height of 24 feet. No lights of any kind shall be placed or erected which diminish the character of a residential neighborhood. And then finally, I call your attention to subsection I of section 304-37.1. It reads, all studies required hereunder will be submitted to the borough for review by the borough engineer and or another expert as reasonably determined by the borough. with those three sections called out for you, did the applicant provide a lighting study?
They have, yes.
Did Gateway retain the services of a sub-consultant to review the lighting study submitted by the applicant?
We did, yes.
And this work was done under the umbrella of Gateway?
That's correct.
Was LLI Engineering the consultant that reviewed the lighting study for Gateway?
Yes, that's correct.
Are LLI's review comments memorialized in the documents that were marked as Exhibit 1 in these proceedings?
Yes.
Based on LLI's review comments, do the proposed lights for the site comply with the criteria set forth in section 304-17 of the zoning ordinance?
Yes, as stated in their letter.
I call your attention to subsection F of section 304-37.1. It reads, the applicant shall provide a noise study establishing that the noise generated by the distribution center will either, 1, comply with the criteria set forth in section 304-23C, 2, not have a material detrimental impact on the surrounding residential properties, or 3, that any potential material detrimental impacts to surrounding residential properties will be sufficiently mitigated by screening, barriers, or other means. I call your attention to subsection F of section 304-23C, which is referenced in subsection F of 304-37.1. It reads, noise which is determined to be objectionable because of volume, frequency, or beat shall be muffled or otherwise controlled, except fire sirens and related apparatus used solely for public purposes shall be exempt from this requirement. Any standard set by an appropriate governmental agency shall be used as a guide. Now, with those sections being called out for you, did the applicant provide a noise study?
They have, yes.
Did Gateway retain the services of a sub-consultant to review the noise study submitted by the applicant?
We did.
Was Babich Acoustics the consultant that reviewed the noise study for Gateway?
Yes, they were.
Are Babich's review comments memorialized in the documents that were marked as Exhibit 2 in these proceedings?
Yes, that's correct.
Did the noise study submitted by the applicant identify any potential material detrimental impacts to surrounding residential properties caused by noise generated by the proposed use?
No.
Nonetheless, did the applicant's noise study propose mitigating improvements to lessen the impact of any potential noise caused by the proposed use on the surrounding residential properties?
Yes, they proposed concrete walls or thickening of the concrete walls.
Did Babich identify potential material detrimental impacts when it reviewed the applicant's noise study?
Yes, they did.
And then did the applicant propose additional improvements to mitigate the potential material detrimental impacts to surrounding residential properties identified by Babich?
Yes, again, that was thickening of the concrete walls to be used as sound barriers.
With the proposed improvements offered by the applicant and recommended by Babich, and based on Babich's review comments, will any potential material detrimental impacts identified by the applicant's noise study to surrounding residential properties be sufficiently mitigated by screening, barriers, or other means?
Yes, in accordance with the letter received.
I call your attention to subsection G of section 304-37.1. It reads, the applicant shall prepare an environmental impact study identifying impacts to air quality, water quality, and stormwater management as a result of the distribution center development. The applicant shall provide a plan to mitigate any material detrimental impacts and the list of the required permits and approvals from all federal, state, and local agencies with jurisdiction over such matters. Did the applicant submit an air quality study?
They did, yes.
Did the applicant identify in its air quality study potential material detrimental impacts arising from the proposed use?
No, none were commented on.
Did the applicant establish that there are no required permits and approvals from federal, state, and local agencies with jurisdiction over such matters that are required for air quality purposes?
That is correct. There were no permits required.
Did Gateway retain the services of a sub-consultant to review the air quality study submitted by the applicant?
Yes, we did.
And in fact, were American Geosciences, Inc. and TRC the consultants that reviewed the air quality study for Gateway?
Yes, they were.
Are TRC's review comments memorialized in the documents that were marked as Exhibit 3 in these proceedings?
Yes.
Based on TRC's review comments, did Gateway determine that the proposed use will not create a potential material detrimental impact as it relates to air quality as set forth in the air quality study submitted by the applicant?
Can you repeat that? Sorry.
Sure. Based on TRC's review comments, did Gateway determine that the proposed use will not create a potential material detrimental impact as it relates to air quality as set forth in the air quality study submitted by the applicant?
Yes, that is correct.
Since the hearings for these proceedings commenced, did the applicant submit a revised air quality study?
Yes, they did.
Did TRC review the revised air quality study?
Yes, they performed a review of that.
Is the TRC review of the revised air quality study set forth in a letter and enclosure dated September 10th, 2021?
Yes.
Now, I previously asked you if the review comments by TRC were memorialized in a document marked as Exhibit 3. This September 10th, 2021 letter is not a part of Exhibit 3, correct?
That is correct. Yes, it would be Exhibit 8.
So it has, since the commencement of the proceedings, been submitted and marked as Exhibit 8?
That's correct, yes.
Okay. And based upon TRC's review of the revised air quality study, does Gateway still believe that the proposed use, based upon the air quality study submitted by the applicant, will not create a potential material detrimental impact as it relates to air quality?
Yes, that is correct.
Did the applicant submit a water quality and stormwater management study?
Yeah.
And in fact, the name of the document is the post-construction stormwater management narrative, correct?
That is correct, yes.
So to the extent I refer to the water quality and stormwater management study using the nomenclature of the ordinance, you would be referencing the post-construction stormwater management narrative, correct?
Yes, yes, that is correct.
Did Gateway review the water quality and stormwater management study?
We have, yes.
Are Gateway's review comments memorialized in the documents that were marked as Exhibit 6 in these proceedings?
That's correct.
The Gateway review proposed improvements by the applicant to mitigate any material detrimental water quality and stormwater management impacts of the development?
Yes, we did perform that review.
Will the required permits and approvals regarding water quality and stormwater management be a part of the land development approval process?
Yes, those permits have been identified at this time.
In Exhibit 6, the Gateway identify with comments items that must be addressed during the land development approval process to mitigate potential material detrimental impacts of the proposed development.
Yes, that's correct.
And if the proposed improvements are implemented by the applicant, and if the applicant addresses Gateway's comments during the land development approval process, and if the applicant obtains all required permits and approvals from all federal, state, and local agencies with jurisdiction over the project regarding water quality and stormwater management, is it Gateway's determination that the applicant will mitigate any material detrimental impacts of the proposed development?
Yes, as stated in our report.
Now, consistent with the previous testimony you've just given, and based upon all of the exhibits that I had you identify and testify to, is Exhibit 7 the overall summary of Gateway's conclusions?
Yes, that acted as a cover letter for the comment letters. That's correct.
Okay, very good. I have no further questions. Thank you.
Thank you, Mr. Ayob. Just give everyone a heads up. We will be taking a break at 8 o'clock, but we do have some time before then to have some questions for Mr. Flynn. So, Mr. Ferguson, do you want to take the first crack here?
I suppose since we can assume that that was all favorable to the applicant, I will.
Okay.
All right. Mr. Flynn, I'm looking at exhibit number 1, and I'm wondering, as you testify, where does it say in exhibit 1, the LLI engineering report, that applicant's light study is compliant with the ordinance as you testify?
As you are speaking to a report that was prepared by somebody else, I will kind of defer to them to speak to that report.
Well, that was your testimony.
Okay.
You testified as the borough engineer upon questioning by Mr. Ayob that the report that you received or Gateway's opinion based upon the report that you received was that the lighting study complied with the requirements of the ordinance. Where does it say that?
So if you do go to the January 4th statement of their report, under additional items, it does specifically identify 304.17 with the maximum height of the poles. At that time, they were indicated to be 40 feet. In the subsequent report, they did address that and have met the code of 24 feet. So that is a portion of that. They have also identified that based on items previously addressed, as stated in March 31st, 2021, that they do show that the calculated foot candle levels are all within the Churchill Borough zoning codes in accordance with 304.17.
So if we look at scope of services on the March 31st, 2021 letter, I'm looking at their comments, at the comments section under scope of services. Now, it says, as an overall comment, it should be noted that the existing campus site has had limited usage for many years, and any change in lighting levels, even though the lighting levels would be compliant with the Churchill Borough ordinance, will be noticeable to the residents who live at the adjacent property. And then it says in bold, italics, and underline that Langen indicated that all ordinances will be met and the light level reading report given to the borough following construction. Isn't that sort of the wolf guarding the hen house? That conclusion, that they're just relying upon what Langen, the applicant's engineer, had to say.
Mr. Ferguson, that's my letter. So is it okay with you if I respond, sir?
Well, hold on, Mr. White, hold on one second. And you know what, we can only do one witness at a time, but if you could stay on call there, we will get back to you, I imagine. Go ahead, Mr. Ferguson.
Rob, I don't know if that was a question that was asked, and as the preface to the testimony, I had indicated that if questions are asked about specifics in a report, that the parties are here to explain them as the sub-consultants for Gateway.
And I think it's
assuming Mr. Flynn doesn't know.
And that was going to be my response, Mr. Ferguson and Mr. Ayob. I certainly appreciate that. And if Mr. Flynn does not know the answer to a question, I think that's the appropriate response. And then Mr. Ferguson knows that he needs to pose that question to the consultant.
Which he indicated already. He asked to be able to defer to Mr. White since it was his report. And it was
well, I think the initial question, and I think Mr. Flynn did answer the initial question by reviewing the report and answering it. Now, Mr. Ferguson, I think now you're getting to the meat of the lighting consultant report. So, you know, if I'm not sure what the current outstanding question is, because Mr. White joined us, but if you could maybe rephrase or reframe your last question just so we can get back on track.
Sure. So this is for Mr. Flynn. So in a letter report, such as exhibit number 1, which is the LLI engineering letter to you at Gateway as the borough engineer, if the basis of your consultant's conclusion is that the applicant's engineer indicated that all ordinances will be met, is that a sufficient basis for your being satisfied that the proposed application would meet the criteria of the ordinance?
No, again, per my previous response, they have stated where and how they do meet the ordinance. For any further elaboration, I would defer to Mr. White to speak to any other question that you have. But I think again, referring back to my initial response, that they have shown and did identify that they do meet the criteria of 304-17.
Mr. Flynn, you've been present and have heard all of the testimony in all preceding 9 hearings, have you not?
That is correct.
And so you've heard testimony from experts who testified in a manner that was contrary to the applicant's experts. You've heard objector testimony, generally attempting to challenge whether or not some of the specific criteria of the ordinance has been met. And so in those 9 hearings following each of these, most of these engineering reports that we're reviewing tonight, has there not been one thing that one person said that affected your opinions in any way, such that you felt that perhaps you ought to modify your opinions?
Mr. Rob, I'm going to object to that question.
You don't have any standing to object.
The opinion that has been offered isn't that there is compliance. If you look at section 304-37.1 subsection F, all it says is the applicant shall provide a noise study. Or if you go to the light study, the applicant shall provide a light study that complies with the criteria set forth in section 304-17. It's not that Gateway is concluding that they do, it's that they've reviewed a study that was submitted, and based upon a review of the study, it shows that there is compliance with the criteria. So as a result, the report as submitted has been approved. This type of questioning is doing the very thing Mr. Ferguson objected to, asking Mr. Flynn to be the final arbiter of whether or not there is compliance. And I'm sure there has been testimony both ways as to compliance and non-compliance throughout all of these proceedings. And that is what the Borough Council will have to decide, not Mr. Flynn.
And Mr. Ayob, I certainly, I think we can all agree that the ultimate determination as to the credibility of the witnesses, the weight of the evidence does rest with Borough Council. And we're certainly, I don't think Mr. Ferguson would dispute that either. And I do think, Mr. Ferguson, the scope, we do need to somewhat limit the scope here to the borough engineer's role, as Mr. Ayob said. I think I do think that that's not an unfair question to ask Mr. Flynn. If he heard something that makes him feel like it does not, the submitted study is not in compliance. And if he did, then that's relevant information. If he did,
you're asking him then, Mr. Rob, to get to the essence of whether or not there is compliance. And all he is testifying to tonight is the very limited submission of a lighting study that shows compliance and that it has been accepted as such, not whether it ultimately does or does not, which is the role of the parties to prove.
The engineer doesn't have a dog in the fight.
Correct.
Okay, then I don't understand why any objection from council to the engineer about the effect of these questions would be even permitted, for that matter. I have nothing but respect for Mr. Ayob. I'll just tell everybody he's one of the finest land use practicing lawyers I've ever met in my life, and that's in my career. But I just don't understand why the engineer has a dog in the fight. My question was simply that all, just to make sure that you understand my question, was that almost all of these reports preceded the hearings, and yet the engineer has not supplemented any of these reports based upon perhaps additional evidence that he's heard throughout the hearing. I'm just wondering why that's the case.
I think if I'm understanding the question, it is, Mr. Flynn, after sitting through 9 hours of hearings, have you changed your determination as to whether or not this study meets the code, or not meets the code, but complies with the review as written or as submitted to Borough Council? Is that your question, Mr. Ferguson?
Not really.
Mr. Ferguson, if I may, I understand what you're saying, and let me just clarify. If you ask if Gateway has heard testimony that might refute the light study, for example, that was submitted by the applicant, so that one can draw a different conclusion based upon that other testimony, I don't have a problem if Mr. Flynn answers that he heard that testimony. You can't ask him if it changes his opinion, because his opinion isn't that a standard has been met. His opinion is that the applicant provided a light study that shows compliance with the criteria of 30417, which is different than an ultimate determination. So his opinion isn't before a hearing that a predetermination has been made that there's been a satisfactory amount of evidence provided to meet a standard. It simply was a report provided that showed compliance. And if his answer is yes, then you had your whole ability to refute that, or the applicant to justify it during the hearing. He's not opining to the sufficiency of that report. It just presented a position.
So, I think with that said, I think Mr. Flynn can still respond to the question as long as it stays within that scope, as you just described it, Mr. Ayob, which is, did you, asking the borough engineer who's been sitting here, did you hear anything that changes your, position as to, whether or not the criteria was complied with as set forth in your report? I think you can say, well, yes, I heard something, and I I now that upon further review, I don't think what I said in the report is correct. Or you could say, well, no, I've listened to that. I've heard it all. And no, I believe that, you know, what we put in our report is the appropriate review. We reviewed the study and we approved it or didn't approve it. Isn't that fair?
Mr. Rob, with all due respect, though, I don't want to disagree with you, but Gateway did not opine or conclude that all criteria have been met. Gateway opined or concluded that a study was provided showing that the criteria were met.
Okay, maybe, yeah, that's a better way to say it. And thank you for, thank you for correcting me. I didn't mean to misstate Gateway's position or Gateway's role. I think that's a better way to say it. But in light of all that, as I said, isn't it still fair to ask the question of Mr. Flynn with that understanding?
If I have no problem with the question, does Gateway change its opinion that a report was submitted regarding or showing compliance with criteria? Because it doesn't go to the ultimate accuracy of the report or a validity determination of it. It just goes to its submission and what it shows.
So in light of that, I'll overrule the objection, Mr. Ayob, but again, Mr. Ferguson, I think you need to stay within that scope, and I think that's a fair sort of compromise here.
Okay, I'm just going to try to move on here. Okay, don't think anybody will mind that, I hope. All right.
Thank you.
So, Mr. Flynn, what do you understand your role to be as the borough engineer when a consultant report that you've engaged leaves a material matter indeterminate? In other words, if there's an item of compliance that the applicant is required to show, and your subconsultant reports that, essentially at this stage, we can't tell whether or not it is sufficient, then wouldn't that change your opinion that there is not a report that demonstrates that on its face? I think that's the distinction that Mr. Ayob is trying to make, that at least on its face, it asserts compliance. What do you do where something has been reported to you that it's indeterminate? We don't know. We don't have sufficient information to draw a conclusion as to whether there's a material impact or not.
Are you speaking in particular to the lighting study and then the letter as Exhibit A specific to the lighting study?
Well, I'm speaking about exhibit number 1. I don't think there's
I apologize. Exhibit 1.
Okay, right. So yeah, I was just speaking about exhibit 1 and specifically the March 31st letter, but this issue actually is a recurring issue in other reports. So if we do find items, I know that you've been asked broad questions by your legal counsel, and generally I know you're saying that the reports, you reviewed them based upon your consultant report, and that those generally show compliance, but when we dig down into some of the details, if your subconsultant report actually identifies items that either are incomplete, indeterminate, or just not complied with, wouldn't that change your opinion once we get into some of the specifics?
In specific, again, to this letter, we have reviewed it based on our opinions of the letter, and I can let Mr. White speak to his determination, but our interpretation is that it has met the criteria as set forth in 304-17, as stated, specifically to meet a height requirement of 24 feet and not to exceed a foot candle of 0.25, which it does clearly state.
Okay. Well, I'm just directing to you the first page of Exhibit 1. So 304-37.1 says that it can't have a material negative impact on surrounding residential properties. As I look at the first page of Exhibit 1, it says in the last bullet point on that page, additional buffers may be required to block light pollution since these properties are at an elevation above the site. And it suggested that, well, we might have to address that post construction, but I mean, doesn't that at least erode your absolute certainty with regard to the compliance of what has been submitted?
Mr. Ferguson, I do want to make sure we're clear for the record, because you read subsection 2 of section E, and those are that this is an or situation, right? So it says, you know, either complies with 304.17, or it does not have a material negative impact, or that any potential impact is addressed. So I just want to make sure we're asking a fair question of the witness.
Right, and we can go to 304.17 also, and you know, there's some of these criteria are somewhat redundant. But I mean, does this, what I'll call at least an uncertain item, or an item that LLI engineering was careful to bring to your attention, that this might be a matter that will require additional mitigation, which has not been proposed? Doesn't that at least erode your absolute confidence that in the reports of the applicant submitted, that they will meet the criteria, they will meet the alternative criteria as set forth in section 304.37.1E?
No, lighting is typically a performance standard, and it is typical that you would suggest that there would be post-operation testing in order to make any determination that it does continue to meet what has been identified within the studies or within the plans that have been submitted. I will let Mr. White extrapolate on that, as it is his report as the specific lighting consultant on this project.
Yeah, Mr. Ferguson, that underlined italics bold, within the ordinances, you don't, it does not require post-construction testing. And we got the applicant to agree to doing post-construction testing, where somebody could walk around with a light meter and determine whether or not the light levels were exceeded for it. And what typically happens during the design and construction phase is there's changes to the plans. There's, you know, maybe trees are going to be added from your previous discussion tonight. There's things that happen that might change the plan that we've seen to date. And Langen agreed that should those plans change, that they would still meet the requirements of the ordinance with regard to the light levels. And additionally, after construction, they would still do post-construction testing to assure compliance.
And however, are you suggesting that there is not adequate modeling that would have satisfied you sufficiently that you would not have had to add that caveat?
No, that's there's the current modeling that we have, we thought was sufficient. But again, we added the caveat, and they agreed to it, that should something change in the future, because of the other things, as you can see, this is a moving project. Other things could change in this, which might affect the lighting levels, and they might need to go back and recalculate them. In addition to that, should something change during construction, there's going to be post-construction monitoring of the site, where they're going to test the light levels and make adjustments as necessary.
So I honestly did not understand. Are you saying that there was not modeling that the applicant could have done to have more adequately resolved that concern?
The concern is the unknowns of what's going to happen in the future, and there's no modeling in the world that can address that.
Okay, it's your opinion, there's no modeling in the world that could have better informed, in this case, Gateway, as to the light pollution that might have been experienced at a lower elevation from the properties below there. There's no such thing in existence.
No, that's not what you asked originally. You asked if it could be modeled to address every possible concern and possible change to it. But if you go back, Mr. Ferguson, and somebody asks the applicant to lower the site elevation and redo the entire plan for it, they can go back and remodel the lighting based on that new plan that they do at the lower elevation.
Okay, so I can't let you rephrase a question that I did not ask. I was asking with regard to this specific concern, legitimate concern that you raised about the impact of light, given the fact that this proposed facility is at a significantly higher elevation than the surrounding residential properties. And my much narrower question to you, which I'm not clear about the answer, so I'm going to ask it again, is it your testimony that there was no modeling that that Langen could have done to better answer the question as to the impact of the proposed lighting on the lower elevation residential properties?
I believe
I'm going to hold on 1 second, Mr. White. I don't know if there was ever any direct testimony regarding that issue. There was just testimony regarding whether or not the applicant submitted a light study that showed it complied with the criteria of 30417. Now we're getting into speculative matters outside of any of the direct testimony of Mr. Flynn or any of the attempt by Mr. White to support the scope of what he reviewed.
Okay, so first of all, once again, I don't understand how the engineer's attorney gets to object to any of this, but so Mr. Flynn testified that he relied upon this report, and Mr. Ayob and Mr. Flynn both requested that if there were any specific questions regarding the report upon which they relied, that I would go to Mr. White. Now I'm doing as you asked me to do, directing a specific question about the report to Mr. White. So Mr. Robb, would you like to rule on that objection?
I'm going to overrule the objection. Mr. White, please answer the question.
Okay. Do you remember the question, Mr. White?
I believe you were asking whether or not they could have modeled the light level at a lower elevation.
Yes.
Okay. They could have, had they known what that new elevation was going to be. But during the design process and the submittal process, they have everything set at a specific elevation. And the model that they did for that elevation as it currently stands on the site plans right now, it complies with Churchill's ordinances. And the modeling clearly shows that.
Okay, but I think you're changing the subject again, because we've seen the modeling, and what the modeling shows is the light levels on the ground surrounding the property. The modeling, as I think you've admitted, did not include modeling that would show the effect of the lighting on the lower elevation properties, and that type of modeling was possible, at least assuming the elevations that are shown in the current site plan.
The way the modeling works is based on the site plan that they have. They model it out to the extent where it is clearly below the light levels that the ordinance has. So for instance, in Churchill's case, the light level is 0.25 foot candles. Once you get beyond that on the adjacent areas, there's no real reason to model it beyond that.
Right, and we heard your lighting expert. You didn't testify at that time, and he was specifically asked about the photometrics that were provided to demonstrate compliance, and he testified that the light levels shown on those photometric studies were actually the light levels on the ground surrounding that property. I get that, but I believe that your concerns, and frankly the same concern that I raised on cross-examination with your witness, was what about those properties on Beulah Road and Greensburg Pike that would actually be looking up into the fixture because they were at such a lower elevation? And so I understand what you're saying. The photometric study, which is actually showing you what the light level is on the ground, appears to be within the standards of the ordinance. But I'm just addressing the concern that you raised, and whether or not, rather than just leaving this to chance or post-construction, whether or not you could have simply asked them to model that. I understand models aren't perfect, but rather than just kicking it down the road, it was possible to model it, was it not?
It would be possible to expand the model in that direction, but based on the light levels that we saw on that thing, we would anticipate those light levels being far below the 0.25 foot candles.
And well, if you're referring to that thing as the photometric study, I'm not sure how you could draw those conclusions if it was possible for persons living on Buell Road in Greensburg Pike to actually look up into the light fixture, because that's a very different bit of information than the reflected light from the ground, is it not?
It is, and you might see the light fixture, but again, on the edges, they all had shields on them. So again,
right. So if I park my car underneath that light and I look up into it, those shields don't do a thing, right? And they're not designed to protect a person who parks under the light from looking up into the light, right?
yeah, if you're under the light looking straight up, but the properties on Buell Road are at such an angle that they're not looking straight up. They're quite a distance to the side.
Right, but these light fixtures, if you take the 70-foot, well, these fixtures will be probably, you know, at least 100 feet higher than Buell Road. And so I understand, you know, that I mean, the conclusion that you just rendered about isn't based on a study. You're just speculating that it's unlikely that they could look up into the fixture, but it could be resolved by a study, could it not?
Again, I believe the current study that we reviewed was adequate. And again,
and yet you admit it did not answer this question. And for that reason, you put it in your report on the first page to make sure that it didn't get lost.
Well, again, we had the applicant to agree for a post-construction actual readings of it, so that if for some reason there is some imperfection or something changes, that it can be addressed.
I understand. I just now want to draw your attention to one other item. It's on page 2. It's the third bullet point down on the March 31st letter. What is house side shielding?
Yeah, that's where the homes are. These particular light fixtures, again, they have an extra shield which drops straight down on it. So if you noticed on some areas of the model that there's a much wider spread in the light, and then the ones that were on the edge of the parking near homes, we had them, or they provided a light fixture with an extra shield to make sure they block any side light coming from it.
Mm-hmm. Right. So that's a shield that would be, so for example, if we were on the east side of the property, that's the Buell Road side, then these house side shielding would be on the east side of the light fixture with the intent of blocking the light from traveling further east and affecting the Buell Road properties. Is that generally the idea?
Correct.
Okay. Now, did the study take into account the area of the building itself? Because the building would not be on the house side of this shielding, right? It would be on the opposite side. And so did you take into account the wall of the building and its reflective properties as seen from a distance?
To my knowledge, yes, that was included in the study.
Mm-hmm. Do you have any idea, So on the east or the west side, which are actually the shorter sides of the proposed building, do you have any idea what the square footage of those walls is?
Not off the top of my head, no.
Okay, wouldn't it make a difference though? Because it's just a giant reflective plane, isn't it?
I wouldn't say, it's not like a mirror. I mean, I understand it's a white building and it is reflective. I agree. Yeah.
Okay, all right. Well, I mean, it appears from the drawings, I don't think they're really scaled, that even the smaller sides of the buildings are about 5,250 square feet of surface. Do you recall the color of that surface?
I do not.
Okay. I mean, wouldn't it make a difference if we knew what the color of that 5,000 square feet of surface would be?
It would make minimal or no difference to the light levels beyond the boundaries of the light study. So you're asking, or you're expressing what would happen as far as seeing something that's illuminated from a distance. So yes, from a distance you can see it, but if you turned your back to it and held up a piece of paper, would you be able to read what was on that piece of paper because of the light being reflected off of it? That's not what would happen. So, but you're right though. You would be able to see those reflected surfaces from a good distance, and more so depending on the color of it.
Mm-hmm. So, but that's not a studied conclusion, right? It's
Correct.
Your general understanding.
Well, the study again is to determine whether or not they're complying with the ordinance of 0.25 foot candles on the ground. And the study did clearly address that.
Okay. That's all I have. Thank you. For Mr. White, anyway.
Sure. Thank you, Mr. Ferguson. And we are now just a minute after 1. So we will take a 10-minute break now. Thanks, everybody. We'll see you at about 10 after 8.
Hello.
Alex, you'll let us know when council's in their place?
Almost. They're just about coming in. Thank you.
Thanks.
We're all set.
Thanks, Alex. Kim, are you ready to go? Great,
I'm ready.
great. I believe we are, we're going to block on the record. We have Mr. Ferguson and Mr. Flynn, I think. Are you-
You're cutting out, Gavin.
All right, do we have Mr. Ferguson and Mr. Flynn?
Yes. Are you able to hear me, Gavin?
I can hear you, yeah.
Thank you.
Sorry, I moved to a different room, thought I solved the problems, but turns out that I'm not good at this. So anyway. All right, so Mr. Ferguson, we left off with you, your cross-examination of the borough engineer. I think you had said you were finished with the lighting consultant. Do you have additional questions for Mr. Flynn?
I do have additional questions, but perhaps I'll move on to the sound study exhibit 2, and perhaps we should just go right to Mr. Babich, who I saw on, oh, there he is. Yeah, he's here. All right. May I proceed then?
Please.
Okay. So, Mr. Babich, good evening. Dwight Ferguson. Don't think we've met before.
Yes, good evening.
So, in your review of the Ostergaard sound study, I presume that you not only review the study to determine whether the study on its face meets the criteria of the ordinance, but that you bring your own experience, knowledge to that analysis so that you make sure that the conclusions are credible. Is that correct?
Yeah, that's true.
Okay. Did you find these conclusions to be credibly reached? The Ostergaard conclusions, do you feel that they use credible methods to reach their conclusions?
Yes, they do.
Okay, let's explore that a little bit. So the conditional use criteria with regard to noise is found in section 304-31. I'm sorry, I beg your pardon. 304-37.1 F. And there appear to be 3 different ways that the noise study can establish that the noise generated by the distribution center will be compliant. The first one is to comply with criteria set forth in section 304-23C. And that says, noise which is determined to be objectionable because of volume, frequency, or beat shall be muffled or otherwise controlled. Then there's an exception for sirens and public safety items. And then it says any standard set by an appropriate governmental agency shall be used as a guide. In this case, Ostergaard made no reference to any other independent standard, whether government, whether by a government or by an association. Did you find that they made any reference at all to any governmental regulations that could have been used as a guide?
They did refer to the state of Pennsylvania requirements for truck noise.
Mm-hmm.
That was the only definite guide that they referred to.
Okay. But in terms of establishing what are appropriate sound levels, they didn't use anything as a guide, but instead developed their own project goal. That's what the term it was that they used. Is that right?
There's no quantitative noise code in the Borough of Churchill's guide.
Okay. So if there was a quantitative noise standard in the borough, it would be more than a guide, wouldn't it? It would be it would be a requirement, wouldn't it?
Standard.
Yeah. Okay. So these apparently could include non-binding governmental standards, such as governmental, such as noise ordinances established by comparable municipalities. That could have been considered, could it not?
Well, that wasn't part of the code.
Well, no, it doesn't specifically say that, but it says any standard set by an appropriate governmental agency shall be used as a guide. So in order to sort of test your conclusions, it would have been at least possible to use any government standard as a guide to see whether or not the project goal that Ostergaard established seemed to relate to comparable standards in comparable communities. It was possible that they would have done that, would it not?
Yeah, anything's possible.
Okay. Okay. And as you said, Churchill does not have an objective ordinance in place. And so it's correct to say that what Ostergaard did was to establish and then establish what they're calling an existing ambient noise level for the purposes of setting what their goals would be for this project. Is that fair to say?
Yes, and I will say that that's what the City of Pittsburgh code also uses. They use ambient noise measurements to determine what is appropriate.
Okay. And they have specific standards about how you establish the ambient noise level, correct?
Yes.
Okay. And in this case, Ostergaard relied upon two different statistical noise descriptors. And one was what's abbreviated as L90, right? And that's the level exceeded 90% of the time. And then an L10, which is the noise level that's exceeded only 10% of the time. That's what they did, right? Those are the two standards they used. Okay. And as Ostergaard said in its study, it characterized those noises that it captured that that exceeded the sound level only 10% of the time as intrusive sound noises.
Yes.
Okay, and those intrusive sound noises are, first of all, sort of statistically infrequently occurring, since they only occur, it's a sound level that's exceeded only 10% of the time of the period that you're measuring, right? So they're somewhat exceptional noises.
Correct. It's
And they're annoying.
noise.
They're usually
transient noise.
I'm sorry?
Transient noise is what we would say. Yes.
Okay, all right. And can you give us some examples of what you consider to be typical transient noises that would be heard in a residential neighborhood?
Birds chirping, aircraft flying overhead, insects, and traffic.
Okay. Okay. And although it was appropriate to determine what were the ambient level noises exceeded 90% of the time, and to distinguish those from the intrusive noises, which occur only about 10% of the time, Ostergaard then used both the L10 and the L90 to set its what it calls project goals, or set the limits for its study. Isn't that right?
Yes.
Okay. And so since the L10 represents intrusive noise, then the result of that study, at least with regard to the trucks, which he isolated from all the other noise sources, is that the existing and problematic and intrusive noise was used to justify future problematic and intrusive noise, rather than to limit noise to a characteristic which is already occurring and acceptable in that community. Would you agree with that?
Can you rephrase that again?
Yeah. What I was saying is, by using the L10 and limiting that to the trucks, that because the L10 represents an intrusive noise, then the result of the Ostergaard study is that existing problematic and intrusive noise is then used to justify future problematic and intrusive noise generated by the distribution facility, as distinguished from using L90, which is to say, this is our normal noise level, which our project goal is to not exceed. Is that a fair characterization?
I would say that it's existing. I would take out problematic, because it is existing noise.
When you say it is existing noise, what's the it?
The it is the fact that this is right against the parkway, and there is existing noise from the parkway.
Yes. And so if we're talking about let's just call it sort of the average or normal background noise, even that which is generated from the parkway, that's captured by the L90, isn't it?
No.
And it's
not the maximum levels.
Well, it's the levels exceeded 90% of the time. That's the purpose of the L90, right?
Correct.
Okay. So, and this L10 is to show the more, that those levels exceeded a small percentage of the time. The exceptional, intrusive, invasive noises that you only hear about 10, that only occur 10% of the time. We get the definitions right. We got the definitions right, don't we?
We do, but you're missing the point that it is the level that's exceeded 10% of the time.
Yes, right. I understand.
So, right. Okay.
Okay. So that by definition it's exceptional. It occurs infrequently because it's only exceeded more than 10% of the time, or 10% of the time over the period that's being measured.
The level is exceeded 10% of the time,
Right.
not the source. The source could be, right.
We're talking about sound from whatever source.
It's the level, not that it's infrequent. You're gonna have those occurrences are gonna occur. Could be frequently, but it's the level that we're talking about that's exceeded 10% of the time.
Right, so exceeding the level is infrequent. Because it's a level that's exceeded only 10% of the time. If we look at it as a spike, if we look at a steady noise source, if we look at it as a spike, then this spike only occurs about 10% of the time. Okay, let's move on. The Amazon facility, Ostergaard identifies as the noise sources, trucks, a large number of HVAC systems, and a standby generator. Isn't that right?
Correct.
Okay. Not that there aren't any other noise sources, but these are the predominant noise sources. And do you agree that those three predominant noise sources tend to propagate low frequency noises?
Name them again.
Trucks, large trucks, HVAC, the types of HVAC systems on the roof of the proposed building, and a standby generator.
Yes.
Okay. And that the low frequency noises are more difficult to attenuate than high frequency noises.
Correct.
All right. And in this case, Ostergaard used only A weighting in terms of its noise metrics. And we agree that A weighting omits and rejects energy below approximately 500 hertz.
It doesn't eliminate it. It weights it differently.
Right. Whereas C weighting includes the low frequency energy.
C weighting, it weights it differently is the way I would put it.
Right. And so if the predominant noise sources tend to generate a predominance of low frequency noises, we would not want to use a metric which underestimated the noise that would be generated by it's discriminating against by a metric which discriminates against the low frequency noises, would we?
No, that's not true.
What is not true? We would want to use a metric that does discriminate against low frequency noise?
No, most of the common noise codes are written in A weighting.
Oh, he
and
didn't.
you wouldn't. What's that?
I'm listening. Go ahead.
No, I'm done. Most common noise codes only refer to A weighting.
Okay. I guess it depends on the purpose for which you're doing the sound study, doesn't it? Which would guide the metric that you would choose to use.
Well, it depends on the local jurisdiction, and in this jurisdiction, you don't have.
Okay, so then there was no code which required the use of A weighting.
There was no code that required C weighting either.
Right. So it was purely in the So in this case, then Ostergaard could purely rely upon what it felt would generate the most accurate information to avoid any detrimental impact on the surrounding community. Could have chosen whatever weight standard Ostergaard felt was most likely to accurately report the impact of the proposed noise from this facility.
I wouldn't say it was their choice.
Whose choice was it?
I would guess, I mean, I guess it can you can rephrase that and say, yeah, it was their choice if there's nothing to choose from.
Okay, well, the choice wasn't arbitrary, was it? I mean, you would hope that that you, Ostergaard, and any sound engineer would first understand that there are weighting filters from which an engineer can choose. Of course, it isn't uncommon, is it, for a sound engineer to perhaps develop a study using more than one weighting filter?
That's true.
Okay. All right. And depending on the noise source and the known types or frequencies of noise that the noise sources are likely to generate, I think we can agree that those would help to guide a sound engineer's decision about which or how many weighting filters that they would use. Fair enough? In the absence of a standard.
It's correct. And we also look at octave band data in absence of the filters, in absence of the C or A weighting.
You do. And
we meaning acoustical consultants.
Could you repeat that, please? We meaning?
I said we meaning acoustical consultants.
Okay. And you're consistent with that because I think you specifically asked Ostergaard to provide that information, and they never did. Isn't that right?
No, they did provide it.
Okay, we'll come back to your report here in just a minute. And did you happen to read the materials provided by Thornton Engineering, or did you hear his Will Thornton's testimony with regard to the Ostergaard report?
I believe that's out of the scope of work that we had to do.
Okay, I didn't know if you were perhaps present and were able to listen to it or not, since you were the sound expert. Mr. Thornton concluded that in choosing to use A weighting throughout the study, that Ostergaard systematically underestimated the noise that would be emitted by Amazon and overestimated the efficacy of the proposed noise barriers.
I don't have a comment on that.
Okay. But you did have comments in your in Exhibit 2, which is your set of review letters of the Ostergaard report, and it was specifically about, once again, the way that Ostergaard, first, as Mr. Thornton testified, selected a a weighting of measurement and omitted a method of weighting the sound measurements, which would discriminate against and omit low frequency noises, even though those were the primary types of noises being generated by the noise sources. And the second thing that Ostergaard did was, instead of doing a 24-hour sound sampling or sound study, so that we would understand what the entire noise, ambient noise was, they took 10-minute snapshots during the noisiest periods of the day. And you, in your review, repeatedly suggested that Ostergaard should have done 24-hour sound studies, not these little 10-minute snapshots. Is that right?
I did initially ask for 24-hour measurements.
Mm-hmm. And what was their response?
Well, I'm going to back up and you mentioned that there were, you said that they took it at the noisiest time of the day. I would dispute that and say they also took it at nighttime between 10 p.m. and 1 a.m.
Would you say that's the quietest time of the day?
It's one of the quietest times of the day.
Would you say it's the quietest time? Since you're only doing a 10-minute snapshot of sound.
I can't make that conclusion based on not having done my own study. I was asked to review their study with respect to the ordinance.
Okay. But if you were asked to do an ambient noise study, would you, based on your own experience, is it your experience that the quietest time of the night is between 10:15 and 11:30 p.m.?
I can't comment on that because I didn't do a study. I didn't do a study at that location, so I can't comment on that.
But neither did Ostergaard.
They provided data between 10 p.m. and 1 a.m.
Right. Well, the question is whether that was the quietest time of the night. And you said you don't know if that's the quietest time because you didn't do a study, but neither did Ostergaard. Ostergaard took a 10-minute sound study between 10 and 11:30. So they wouldn't know if Churchill was generally quieter between 2 p.m. and 4 a.m. or 2 a.m. and 4 a.m. themselves, would they?
Between what time of the day?
2 a.m. and 4 a.m.
Yeah, and I believe that I can't comment again on that time of day at that location.
Right. Nobody knows if that's quieter, do they? Based upon Ostergaard's study.
Based on the time of day they took measurements, no, we don't know that. But
Right.
we can't assume that it was quieter either, based on their study.
Right. But we have to but all we can do is make assumptions because they disregarded your recommendation, which was the second point that I think you were going to respond to about the repeated recommendation to Ostergaard that they do a 24-hour, they gather data for 24 hours, not just in a few 10-minute increments. They did 6 10-minute increments. So they actually studied during morning rush hour, the beginning of the afternoon rush hour, and when the Woodland Hills school buses start departing, and then between 10 and 11:15 p.m. Which, you know, in your experience, wouldn't those typically be noisier times of day in terms of traffic?
Not between 10 and 11:15 p.m.
As distinguished from the early hours of the morning.
I can't make that determination.
Okay, but didn't it raise a red flag to you to see that a person, that Ostergaard was developing their ambient noise level by taking very short snapshots of sound during morning rush hour the shoulder of the afternoon rush hour and calling between 10 and 11:30 nighttime. Did that concern you that they might be trying to develop a study that resulted in a much higher ambient noise level so that it would make achieving their project goals easier? Did that not occur to you?
That wasn't the conclusion I drew, but I did
Did it
ask for
occur
a
to you?
20. I did ask for a 24-hour survey, but that's not the conclusion I drew.
Okay, you did ask for a 24-hour sound survey. I think that's the term you used. Why did you ask for that?
Because that is something that I would have done knowing the type of noise sources that are in the area.
Mm-hmm. And the response from Ostergaard was what?
That the 10-minute samples were statistically valid.
Okay, so the answer to you was no, we're not doing a 24-hour sound study.
They did not say that they would do that.
Okay.
That is correct.
Right. And so, you know, as a kind of real world example, if I am trying to convince you as to what the typical ambient noise levels are, and I go out these select times of day, and I just take samples for 10 minutes. If I had done a study for 24 hours, then isn't it possible, likely, that that over a period of time, since we are since the final number that we're arriving at is a single number based upon the period of time that we study, that the noise that we got in that 10-minute sound bite would be diluted over a period of time and result in a single number, which is a lower ambient noise level.
Again, I can't make that conclusion because
Okay.
I haven't done my own survey, because sometimes it would and sometimes it wouldn't.
Okay, and because sometimes it would and because sometimes it wouldn't, that's one of the probably several reasons why you asked Ostergaard to do a 24-hour study. Is that fair?
Again, I asked them because I just wanted to have that additional data.
Because?
Again, to prove or disprove a statistical validity.
Okay. And if you ask, if you're reviewing a sound study and you ask the sound engineer to provide additional information, so as you stated, you could validate their conclusions, and they don't do that for you, does that give you any reason to be concerned about the weight that should be given to their conclusions?
No, because yeah, again, they reacted to the concern, and again, their studies said that they were confident that it wasn't going to be a problem.
And that was good enough for you. Just, they said, you know, the 24-hour sound study instead of our 10-minute sound bites, we're just confident that we're giving you what's accurate. So you should back off of your request and we're not going to do it. And for you, that was just fine. You just accepted that as being acceptable to you.
Again, we went back and forth a few times, and I asked a couple times, and we didn't get the data. So,
Okay, okay. All right, so I'm now looking at Exhibit 2, which is your letter to Gateway Engineers dated July 2nd, 2021. Do you have that?
yes.
Okay. The third paragraph says, the letter addresses the noise level of heavy trucks. What letter are you referring to?
The letter dated June 18th. That's in the previous paragraph.
Okay, all right. Now, in the next to the last paragraph, it said, Hillwood is addressing the possibility of low frequency noise from idling trucks with concrete sound walls, which have more density than other sound walls. So you were keenly aware that one of the critical issues for meeting the criteria of the ordinance was low frequency noise from the large trucks that would be servicing this facility. Isn't that right?
Well, I did say that it's something that needed to be addressed and reviewed.
Okay. So, I mean, in this letter, that is an issue that's top of mind. You are identifying low frequency noise from the trucks is an issue that's going to have to be mitigated by a sound barrier, and you're proposing that simply if they're just thicker walls. Do you think the thickness of the wall is the primary way of mitigating low frequency noise? Is that the primary way?
Well, they reacted to it with the thicker sound wall. That was their reaction.
Is thickness the primary way of mitigating noise, low frequency noise though?
Well, it can be if you're in the acoustical shadow of that wall.
And so to be within the acoustical shadow, that's an issue of the size of the wall, is it not?
The height,
breadth.
yes.
Okay, so thickness alone is only effective to the extent that it's within the acoustical shadow of the noise source, right?
Correct.
Okay. Now they're proposing, all right, the next sentence there says intermittent low frequency noise from trucks entering or exiting the facility will not be able to be addressed. Could you tell everybody what you meant by that?
Well, again, the truck traffic can only be outside of the walls, can only be affected by how many trucks are traveling and the frequency and the number.
So is it safe to say that, well, the sound walls are, do you know where the sound walls are proposed to be constructed on this site?
Yes.
Where's that?
On the, I believe it's the east and the west side of the site.
But they're actually located on the perimeter of the parking areas, right?
Right.
Okay. So when those trucks are outside of the perimeter of the parking areas, such as you stated in your July 2nd, 2021 letter, when they're entering and exiting the facility, they will not, that low frequency noise from trucks entering or exiting the facility will not be able to be addressed. In other words, there's no mitigation of that sound at all.
Correct.
Okay. And when you use the term intermittent to describe trucks entering or exiting the facility, what did you mean by intermittent?
Intermittent meaning that it's not going to be a steady state noise source. It will be if it would be dependent on how many trucks enter and exit.
Well, that's two different things, isn't it? So it might be intermittent. Would it be fair to say that when you use the term intermittent, you mean that if there's some period of time between trucks entering and exiting the facility, that if that time is long enough, it'd be correct to call the low frequency noise from the trucks entering and exiting as intermittent. If the interval between the trucks entering and exiting was long enough, you would then call it intermittent.
I don't understand what you're getting at.
I don't understand what you're getting at by using intermittent, so we're trying to figure that out. So you called the trucks entering and exiting the facility as intermittent, and I'm asking you if by the term intermittent, you're suggesting that the time between a truck leaving and a truck coming is great enough that it isn't sort of a steady stream of trucks, but rather they're occasional. Is that what makes it intermittent? If not,
Yes.
tell me why
Yes.
you chose it
No,
as intermittent.
that's what I mean. It's intermittent based on the fact that it would be not steady state.
So if it was if it was a steady stream of trucks going in and out, it would be wrong to call it intermittent. Would you agree?
Well, it's it's not my understanding that there's going to be hundreds of trucks lined up.
Would it have to be hundreds?
It would if it's steady state.
Okay. And what was the source? I mean, did you get any information about the trucks entering and exiting this site other than what you got from Ostergaard?
No, I mean, that was the only study I was asked to comment on.
Okay. So so you just relied upon Ostergaard's representation as to the frequency of trucks going on and off the site. Fair enough?
Correct.
All right, now I'm looking at your letter of April 28th, 2021. And I'm looking, so what you're, in the next to the last paragraph, if you have that paragraph is in italics because you're actually quoting, just see here. Ostergaard here. And it says Ostergaard is comparing site maximum sound levels when vehicles are closest to receptors and comparing them to L10 statistical sound levels of existing conditions. This is still quoting Ostergaard. While this approach is conservative and appropriate, should model results be analyzed statistically in a similar manner, even over a short period of time, we are confident that the low frequency issue you have identified would not be realized as these intrusive sources are transient and dynamic. Is that an example of the representations from Ostergaard that you relied upon to conclude that the trucks going in and out were transient and dynamic as opposed to a steady stream?
Well, I agree with the fact that they are transient. It's not a steady stream. There's no.
Ostergaard told you that. You're just saying.
Well, I mean, no, I mean, they said that there's 13 per hour. So that's not, to me, that's not steady stream.
13 per hour. So more than one every 10 minutes?
Right, which, yeah, that wouldn't be steady stream.
For a 24-hour period? Not during rush hour, but just 24 hours?
I'd have to look at this again a little more closely.
Okay. Can we agree that if the truck traffic was what was steadily going on and off the site at what I've said kind of earlier, at shorter intervals, I guess less than 7 or 8 minutes an hour, or 7 or 8 minutes at a time, that you would then want Ostergaard to use the L90 standard?
Yes, I think so. I mean, I think it would depend if you're talking about a steady stream, and that's not a steady stream.
Mm-hmm. Okay. So I'm turning now to page 4 of that report, conditional use compliance, and I'm going down to number 2 here. It says, you mentioned providing the octave band data. Number 2, your comment says, in addition, the LEQ or L90 shall not exceed 5 decibels of the existing background noise level in any one octave frequency band between 16 hertz and 4,000 hertz at any residential property line. 9 octave bands are identified at the following center frequencies. And then in bold, it says octave band data was not provided. This additional information is requested for all data reported. Was the octave band data provided to you by Ostergaard?
Yes, and it is on the next page, and that was the original comments, and then the bold and red is the follow-up to that.
Okay. So then, okay, so the red is whose comment, just to be clear?
It's my comment. The
Right.
Black bold was the previous comment from the previous report, and then this is the bold and red is from the March 25th report.
Okay, so let's look at that. It says Babich Acoustics agrees with Ostergaard's assessment of using L10 to compare existing and predicted noise levels. Now, L10 wasn't used for all existing and predicted noise levels. It was only applied to trucks, right?
To transient noise levels, correct.
Okay.
And that's appropriate.
This is appropriate criterion for transient noise levels, because at least at this point you were convinced that the trucks were transient noise generators, right?
Correct.
However, after reviewing octave band data between Ostergaard's predictive model and measurements gathered on site, it shows that low frequency noise levels will likely exceed transient noise levels at 63 hertz and lower during nighttime hours by approximately 9 decibels at location 2, location D in noise model, and 6 decibels at location 4, parenthetical language. 6 decibels is a noticeable increase, whereas 9 decibels is almost twice as loud. And then you pull from the Ostergaard report to make your point, right? So even based upon Ostergaard's study, it was your conclusion that at some locations, location 2, that the noise generated from that site, even with what you're calling transient truck traffic and using the L10 standard, that it would be twice as loud as what is currently being experienced there as measured by Ostergaard, correct?
Well, it's from their study. It's not what was measured. It's from the
Yes,
noise model,
yes.
from the noise model.
Yes, that's what you drew from their study.
So it's the theoretical model. Yeah. And again, they
It could
reacted
be worse.
they reacted to our concerns with the thicker sound wall
Okay,
from this particular report.
yeah, but they didn't change the dimensions of the sound wall. It's still just 15 feet tall, right?
Correct.
Okay. Are you convinced that a thicker sound wall is going to mitigate the propagation of that low frequency noise?
Well, the thicker wall will help with if it's in the acoustical shadow of the wall.
Okay. And then down on number 3 here, you called out what we discussed earlier in your prior comment, in number 3 on page 5, for locations with frequent transient noise sources along highways or roads with frequent cars passing, L90 statistical sound pressure level data shall be provided. So help us to understand why you did not want Ostergaard to only provide L10 data for locations with frequent transient noise sources, but you were requiring them to provide L90 sound pressure level data. Why?
Well, again, it's dependent upon how close it would be to the roads or highways with frequent cars.
But why did you want to know the level exceeded 90% of the time and not just what Ostergaard was giving you, which was the level exceeded 10% of the time?
Well, I think we're mixing up different data here.
Well, you were asking for the L90 along highways or roads with frequent cars passing, where they had only previously given you the L10. Why? Why did you want L90?
Well, actually, I wanted L90 in addition to LEQ because I wanted to remove the transient sources. So I wanted to be able to understand what the steady state sound was, which is what L90 will provide.
Okay. And then in your prior comment, which is identified in the bold black, says this data has been provided, but only for 10-minute increments. And that wasn't satisfactory, correct? At least when you wrote at least when you put in the bold comment there.
The previous, that was from the previous report.
And you put that in because that wasn't acceptable to you. You did not feel that the data being provided for only 10-minute increments was satisfactory. And that's why you made a bold comment and carried that over from the prior response letter, right? You weren't complimenting them, right?
Right. I mean, I did ask for additional data is what.
Right. And so, and then in the red comment, which is the one applicable to this one, it says it was discussed that additional noise data was not going to be collected at this time. So how do you reconcile your let me just get this. I don't see a prior letter from which that bold came, but I think I can figure that out here in a second. Well, we know the preceding letter is, your comments were in this bold black here. So was that reconciled for you in some fashion, that in the prior iteration, you were calling out a concern that the data was provided for only 10-minute increments, and you wanted a 24-hour study, but at the end of the day, they weren't going to do it. And how did that leave you?
Well, again, it
confident in your conclusions?
it wasn't a requirement. So
Okay, it wasn't a code requirement, you mean?
it wasn't a code requirement. There's no way that, yeah, I could make that happen.
Right, but you're being asked by the Borough of Churchill through its engineer to put your opinions and your reputation at stake here, right? It wasn't a requirement. You couldn't force them to do it. I get it.
Right, and I already did that. I already did that with this letter. This is a condition of the conditional use.
You already did what?
I already made the comment, and it's already in writing, and it's a condition of the conditional use.
I'm talking about your comment that the data has been provided for only a 10-minute increment. That's not a condition of the conditional use. So you're confusing me. What are you talking about?
I think it is. I think it's already said that the data wasn't gathered, so it's in writing. And
okay. So my understanding, it sounds like you're speaking in subtext here. It sounds like what you're saying is that when Borough Council gets a copy of this letter and they see that you called out the fact that the data was only provided for 10-minute increments, and that just to be clear, later in this same report, next page, you made specific requests for a 24-hour survey, and then in red, we're not going to go back and forth too many times here. It says it was discussed that additional noise data was not going to be collected at this time, and that's the end of it, right? And council or Gateway Engineering, they can draw whatever conclusions they want. You're not expressing an opinion here. You're just saying, I asked for this and I didn't get it. And Gateway and council can draw whatever conclusions they want. Is that what you're saying?
I'm not saying that, no. I'm saying that what was presented to me, I asked for other information. It was not provided, and Hillwood's consultant provided the study that they were going to provide.
Okay. You're an expert here. We're expecting more from you to just say they provide what they provide. I get it. I think we're done with that. I get it. You asked them for it. I mean, I'm just reading what it says, and you just pointed out in your report it wasn't coming, and that's it, right? You're not offering any judgments about that. Is that fair to say? You're just saying you didn't get it.
Correct. In that statement, yes.
Okay. All right. Now, I mean, sorry to flog this dead horse too much, but if we go to number 4 on the preceding page, this is again about the, this gets behind the explanation. This is paragraph 4, second paragraph there. 4, noise measurement should be gathered for a minimum duration of 1 hour during both daytime and nighttime hours. Skipping down next paragraph. In the Ostergaard survey, only 10-minute measurements were completed. 1 hour measurements are preferred to correlate L90 and LEQ data during both daytime and nighttime at all survey locations. Ideally, the measurements would be completed for 24 hours at each location in order to establish a day-night level at the adjacent residential properties. Okay. And without torturing everybody, that appears quite a few times as we go through that report. And so just to be clear, so that's the report dated March 25th. And as we said, then there's a report of April 28th, which we've already talked about a little bit. So are these each of these letters reviewing the Ostergaard study, are they intended to sort of stand alone? Because you don't carry, like in the April 28th letter and the July 2nd letter, you don't carry forward the prior comments. So can we just assume that by virtue of the fact that you wrote a letter dated April 28th and the letter dated July 2nd, it isn't intended to supersede or disregard the prior comments appearing on March 25th. Is that correct?
Yeah, I mean, yeah, that's correct. It doesn't eliminate a report previously written.
Okay. So, okay. So, all right. I think that's all the questions I have for you, Mr. Babich. Thank you very much.
Sure.
Thank you, Mr. Babich. There may be folks who have additional comments or questions for you down the line here. However, it's at the risk of being a little disjointed, I think it's better to get through Mr. Ferguson's cross-examination of the borough engineer's presentation, and then we can move on to other party objectors. So we'll let you go for now, but don't go too far if you don't mind. Mr. Ferguson, additional questions for another witness?
Let me just take a look here. So, no, let me just ask Mr. Flynn. So for the record, you were present when you heard Mr. Babich testify. How do you reconcile the requests by Mr. Babich on behalf of Babich Engineering to Ostergaard for additional data, and then you see from Mr. Babich, he just, objectively and non-judgmentally reports that additional data wasn't provided. And unless I'm missing something, I don't see anything in Mr. Babich's report that is in his, in any of his letters that concludes that the Ostergaard reports meets the criteria of the ordinance on its face. To the contrary, the very last letter points out that low frequency noise from trucks entering or exiting the facility will not be able to be addressed. So tell me what your process was then in in testifying that by reading the Babich study, you concluded that there were no material detrimental impacts. That was a question that you were asked. How can you be satisfied with making that recommendation to council in light of the lack of information that was requested and some of the issues about how the study was made? There was not some L90 data. There was not a full octave of frequencies provided. There's no mitigation of low frequency sound from trucks entering and exiting the site. Maybe they'll thicken the walls, but we don't know anything about the shadow of the acoustical shadow of the area, that they will never be behind the wall and entering exit. How do you reconcile that now to say that with council with 2 thumbs up that you're completely satisfied that they've met the criteria as to sound?
As was stated by our consultant, Babich, and in coordination with him, that information was requested, but was not required. The methodology utilized by the applicant is a typical methodology. He did request additional information, but in our coordination with him, it was understood that they could reasonably mitigate any impacts created by the site.
Based upon the information given.
Based upon the information given and the information that was reviewed as part of our scope.
And as you sit here today, having testified as to that, you know, are you 100% certain, as you represented this council, that the Ostergaard study can be relied upon because they did not selectively exclude low frequency noise by applying the A weighting? They did not artificially increase the ambient noise level by characterizing a 24/7 flow of trucks as intermittent and then applying the L10 standard to it, and by taking 10-minute snapshots of sound during what might be the noisiest times of day. Does any of that make you less than 100% certain that the Borough of Churchill and its residents are relying upon the opinion of Gateway engineers that the Ostergaard study meets the standards that it needs to?
It is not typical to have a 100% certainty of anything of this nature, in which it is a performance standard, and what is objectionable to one person may not be objectionable to another person. So in that regards, again, in speaking with our consultant, as I am not a sound expert, but in speaking with him, that they did use a typical approach and methodology in the review, and that their study does show that they can mitigate it, as was stated by Mr. Babich as well, that we did indicate within our comment letters that we believe that it can be reasonably mitigated by meeting any additional comments or conditions that we may have stated. So in that sense, it does state that may be something, and in this case, similar to lighting, as a performance standard, it has been stated that there would be post-operation studies for something that may be unknown at this time, but they have met the minimum or the requirements to evaluate and determine impacts, and have shown that they can mitigate those impacts.
Even in light of Babich's conclusion that the traffic entering and exiting the site, that the low frequency noise can't be mitigated, you still reach the conclusion that it can be. Was there another study that you relied upon that reached a different conclusion than Mr. Babich did about trucks entering and exiting the facility that you can't mitigate that low frequency noise?
Again, based on the official standards, which there are no specific standards, it was understood that they had identified impacts and could mitigate those impacts based on a typical methodology. So again, I wouldn't want to speak to something outside of that.
Okay. All right. Thank you. That's all the questions I have.
So, Mr. Ferguson, no other questions for Gateway and its consultants before we move on to the other party objectors? And you're muted right now, but I can give you a moment to think about it if you want.
Well, the answer is no. They did refer to the air quality study, but I don't think that there was any. I don't believe that Mr. Flynn was questioned about the traffic study. So no, I don't have any other questions at this time.
And Mr. Flynn, to be clear, will Gateway, and I'm not trying to pull fast one on Mr. Ferguson, so will Gateway be putting another witness on the stand here, the virtual stand to testify about traffic?
No, that was included within my original testimony. We do have an expert within Gateway who could speak to specifics of traffic, but I did comment in my testimony regarding the traffic impact study submitted as well as the parking study that was submitted.
I couldn't recall, it was a few hours ago now, so I had a feeling Mr. Ferguson may have a couple questions related to traffic, and I didn't want to pass them on by before he got the opportunity.
Yeah, well, yeah, I didn't, I must not be keeping a good scorecard here because I didn't recall anything about traffic or parking for that matter.
Parking, I certainly recall, and now that I'm thinking about it more, I think traffic was covered. So let's, with that in mind, and now that you're aware of that, do you want to take a minute and think about questions you may have on traffic, or are you ready to go now?
What I'd like to do is maybe just let any other independent objectors ask their questions, and I'll see if I have any traffic questions, if that's okay.
I think that's fair. All right, so it's 9:30 now. We're gonna go about another 30 minutes before one more short break at 10 o'clock. We got a hard stop at 11. Again, my apologies for the web camera failure today, but we're working through it, so I appreciate your patience. Alex, who had the first hand up? Who are we gonna turn to for questions of party objectors?
Good question about first, but Sandy Fox, in the order that I see him on my screen, is first, and then Dr. Casman and April Kline. So those are the three individuals who have their hands up. And so I guess you want to start with Sandy?
Sure, why don't we do that? Go ahead, Ms. Fox.
Okay, thank you. I wanted to ask questions regarding the air quality study. Would that be Mr. Flynn?
You can ask me the question if it is very specific to the study and our comment letter. We do have Patrick Fennell of TRC who authored our comment letters.
Okay, very good. It is somewhat specific. The first question I have is that Epsilon wrote a letter dated August 21st of this year, noting the comments from TRC regarding the air quality modeling study from March. And they noted that TRC recommended that Epsilon modify its conclusion regarding the projected impact of the project on air pollution. Are you aware of the comment that they made regarding Epsilon's conclusion?
Yes.
Okay. What is your recollection of that?
And because Mr. Fennell did report on that, I'll give my recollection first. They just did want them to be specific within their statement, as well as the comment was in relation to the changing of the plans and that they would be providing a revised study based on the revisions made within the plans.
Okay, specifically, I'm referring to conclusion. It's listed as number 34 in the letter, and it says that the modeling report, and this is referring to Epsilon's March study, states, quote, since all predicted concentrations are below their applicable national ambient air quality standards and or air toxic standards, it can be concluded that the proposed project will not cause or contribute to a condition of air pollution in the area, end quote. And TRC's comment was, quote, the predicted air quality impacts of the project plus background concentrations do not exceed a national ambient air quality standard or an air toxic standards. However, the project will result in air emissions and contribute to air pollution in the area, end quote. So that's what I'm referring to in terms of that. And at that point in the letter, Epsilon did not comment, but Mr. Sabato noted in his testimony in August that they did revise their comments. Do you know what their revision was to that conclusion?
Yes, and I can pull that up for you. And I believe my understanding that was specifically in relation to the fact that it said that it would not contribute, and being that all projects in some way somehow would contribute, and
Right.
that the specific terminology was best stated that they would not increase beyond an acceptable standard.
Okay.
Patrick, I know that you understand, or you reviewed this obviously in much greater detail. If you would be able to speak to exactly their revision in the most recent application or study that they provided.
Yes, they did not make the statement that it would not increase air pollution. The final report, or the August report, no longer asserted that.
Okay. What I'm reading says in their final report in August 2nd, 21, that the highest, okay, I'm sorry, that with a background value of 10.6 micrograms per cubic meter, and they're talking about PM 2.5, added a total concentration of 10.9 micrograms per cubic meter is obtained for the project below the annual PM 2.5 National Ambient Air Quality Standard of 12 micrograms per cubic meter, and completely attributable to the ambient background concentration. Do you agree with Epsilon's assertion that the increase with the project under their modeling is completely attributable to ambient background concentration?
No, but I don't think it's it's not material. You know, there's a small increase predicted by the model, but the predicted impact is still below the National Ambient Air Quality Standard.
Okay, are you aware that the World Health Organization standard for PM 2.5 is lower than the EPA standard?
I know that there has been, well, the ambient air quality standards are reviewed by EPA every 5 years. And there are many recommendations made by many people, and you know, and the EPA weighs those factors and makes a conclusion accordingly. I'm
Right.
not familiar with the World Health Organization standard.
Okay, their standard is 10 micrograms per cubic meter. So the
Can I,
projected level,
on what basis though?
on what basis?
Yes, these standards are all statistical in form. And so you just can't pick the number out without also relating the statistics that is used to arrive at that standard.
Mhm. Well, are you aware that there are multiple peer-reviewed scientific studies that correlate particulate matter 2.5 with an increased risk of lung cancer, heart disease, and premature mortality, in addition to other ailments?
I haven't read hundreds of peer-reviewed, so I can't comment on that.
Okay.
I would go further with that in discussion with our consultant, the review was based on current standards that exist and not other alternative standards or alternative thought processes.
Okay, and yet the comment from TRC that I'll go back to, referred to in Epsilon's letter to Langen, said that the predicted air quality impacts of the project plus background concentrations do not exceed a national ambient air quality standard or an air toxic standards, which is incorrect because it exceeds the WHO standard.
No, no, that's not correct, ma'am. No, that's not correct. The toxic standards are are for the various toxic air pollutants. Those are not applicable to criteria pollutants such as PM 2.5.
The World Health Organization has a standard of 10 micrograms an annual of 10 micrograms per cubic meter.
But that's not material to this. The World Health Organization's standards are not relevant to this application.
Okay, that's your opinion. Are you aware of a Harvard study that looked at across New England at 6 different sites that looked at premature mortality as related to particulate matter 2.5 below 10 micrograms?
I haven't read that paper. No.
Okay, according to that study, there was an association between exposure, both short and long-term exposure to PM 2.5 and premature death in adults 65 and older. So the reason I'm saying this is that I believe, obviously, that it is detrimental, and I'm concerned that TRC does not reach this conclusion given the scientific studies that have been peer reviewed that are out there, and our knowledge of the dangers and the deadliness of fine particulate matter.
Ms. Fox, is there a question there?
Well, I'm wondering how you reconcile the levels with the comment that, yes, this will not be detrimental. How do you reconcile that to air quality?
I did not say they were not detrimental. I said they meet the established standards.
Okay, so you're saying that the air pollution that will be emitted from this project is detrimental.
Any pollutants that are emitted could be detrimental. But again, that's not the question. The question is, the issue is, does this meet the established standards? And the models predict they do.
Okay, but the zoning ordinance is also concerned with matters of air quality and what is detrimental to the environment.
I believe the words are material.
And you do not believe that the pollution from 700 to 800 diesel tractor trailer trucks a day going in and out of the facility would be detrimental to the air quality or to the health of people?
Again, the standard is not whether it's detrimental. The standard is the criteria is whether it's materially significant, whether it's significant or not.
Okay.
And the established standard for determining that are the National Ambient Air Quality Standards, and the modeling done by Epsilon shows some increase in pollution in the concentration, but the predicted impact plus the background is less than the standard.
Do you believe that it's possible that Epsilon underestimated the amount of PM 2.5 fine particulate matter in this modeling study?
I think they use the established methods for their calculations. They use the EPA approved models. They use emission factors published by the EPA. And in fact, some of the methods they use to calculate the stationary sources were quite conservative. For example, they assumed that the heating units were operating at their full capacity every hour of the year, when that's simply not going to occur. The heating units are sized for the hottest days or the coldest days. So I think their methods were generally conservative.
And yet, Mr. Sabato indicated under cross-examination that he used statistics from the traffic study that were reported under cross-examination by Mr. Prisk, that there would be 7 tractor-trailer trucks on the site at any one time, which appears to be a gross underestimate. There are 49 loading docks and over 300 truck spaces at the facility. So
Been stated.
I'm sorry.
I was going to say, as has been stated, we reviewed it based on the study that was prepared, and the information within that study utilized proper methodology.
Okay. Are you aware that the EPA is poised to lower the acceptable levels of fine particulate matter on the annual level to between 8 and 10, which would render the proposed level in violation?
I know that the standard is under review. I don't know what the EPA will do.
Right. They did issue a press release saying that they were reviewing the studies that looked at harmful health effects with the current level. Okay, that's all my questions. Thank you.
Thank you, Ms. Fox. We have another 15 minutes. We have 108 participants, by the way. I know Alex likes me to point that out throughout. So thanks for everyone hanging on with us. Is it Dr. Casman next, Alex, or Ms. Kline?
Dr. Casman and then Ms. Kline.
Okay, thank you. Go ahead, Dr. Casman.
Thank you. I think I need to start by asking Mr. Ayob a question, because I was confused by the conversation between Dwight and Mr. Ayob. So if I understand this, Mr. Ayub's point is that all the Gateway needed to do was to confirm that a report was submitted showing an attempt, well, showing compliance, but didn't have to rule on whether the compliance was actually demonstrated. Is that correct?
So normally attorneys aren't subject to examination, but I'll let Mr. Ayob respond to that if he so chooses.
Well, Mr. Rob, I do agree. Usually lawyers don't answer questions, but I believe that what I stated earlier was that based upon the testimony provided by Mr. Flynn, Gateway had to look at what was submitted to see if what was submitted was in compliance with the requirement set forth in the conditional use ordinance. So there had to be a determination made whether an analysis or a study was submitted and whether that analysis showed what was required to be shown by the zoning ordinance. But ultimately, as to whether or not the condition has been met or satisfied is not a determination to be made by Gateway. A conditional use is to be approved by a borough council. And in so doing, the borough council in this instance needs to look at each of the individual requirements or specific conditions and make a determination whether or not they're satisfied.
This is the thing I don't understand. The submittal of the report is not disputed, nor the claims of the applicant that they meet the conditions. The reason for the review is a judgment of whether or not they are in compliance, and that's a difficult question, not an easy question. And I'm hearing you say that they only have to answer the Gateway only has to answer the easy question of whether or not they submitted a report and made an argument of compliance. Is that it? Am I missing something?
You know, with all due respect, I don't represent you, and I don't want to counsel and advise you as to what the role of the borough is with regard to a conditional use application. It's the borough that makes the determination whether a conditional use should be granted or denied, not the borough engineer.
Thank you, Mr. Ayob. Dr. Casman, do you have questions for the Gateway witnesses?
Oh, yeah, I do. I just wanted to know what, whether or not their opinions matter, basically.
You can go ahead with your questions.
Okay, so I just have a couple of starting questions for Mr. Flynn. He said that he had a bachelor's in engineering, but what kind of engineer are you, Mr. Flynn?
A civil engineer.
And so did you personally review the traffic and parking studies?
No, we did have a traffic engineer from our office, or our traffic engineering team had performed the review of the traffic study as well as the parking study.
Did you personally review any of the studies?
Yes. Well, in accordance with a team, or as is typical, I utilized a team of specialists specifically for the stormwater review, but I did author and sign the stormwater study review, and ultimately the conditional use cover letters associated with all of the reviews.
Okay, well, let me start with the stormwater questions then. There is the borough requires that there's no water pollution be allowed. So and the post-construction stormwater management element submission, what pollutants did they measure? Or did they predict, model rather?
Again, can you refer to any specific exhibit that has been prepared by the applicant?
Well, the applicant actually did not have a water quality report, but it had 9 pages of a spreadsheet from the PADEP in their 1,000-page report that talked about some nutrient pollution, and that's all the. So I wanted to talk. I wanted you to tell me if they did anything in addition to the nutrient pollution.
The applicant did provide the appropriate review as per required by the regulatory agency for water quality, and that is set forth by the DEP utilizing the DEP spreadsheet that exists.
Right, and Gateway identified a problem with that spreadsheet, correct?
Initially in the first preparation, or the first study that was provided, correct.
Have they revised it?
Excuse me, you trailed off there.
I have not seen a revision posted.
Ms. Casman, we can't hear you. You might need to put your phone up to your face better, please.
Let me go plug in a microphone.
Can you hear me now?
I can, yes.
Sorry, I wasn't heard before. So, so they have revised and resubmitted the spreadsheet. Is that correct?
Yes, they did provide revisions to that spreadsheet, and the May 10th, 2021 stormwater management narrative that was provided.
Right, May 10th. May 10th, in the May 10th submission, it said that the BMPs would allow no nitrogen, phosphorus, or TSS to escape the BMPs. That's an error, of course. So how can you sign off on a ridiculous statement like that?
The applicant did fill out the spreadsheet appropriately. That is the way that the spreadsheet provided does make the determination of the water quality and how the MRC or managed release concept, best management practice that they had chosen, that is how that that calculates water quality.
Right, that's how it calculates it when it doesn't recognize the BMP entered. When it doesn't know what the efficiency is, it gives a zero result. It's an error, and I can see it. You're accepting. You accept that that is correct. Is that Gateway believes that the calculation that they submitted that says that after increasing the impervious area by 24 acres and changing it from low traffic to high traffic, that the water quality will be less than it is pre-construction? Gateway believes that's true and a correct calculation?
Based on the spreadsheet provided by the DEP, that is how an MRC or a managed release concept BMP is calculated. That is correct, and I believe that is the point that you have missed in your review of it, in that you are not taking into account the managed release concept, which is a newer concept or newer design methodology that is used for water quality.
I respectfully disagree, because a managed release is about controlling flow volume and rate, but the pounds of pollutant it's a different story. So, but we can disagree with this. So I wanted to also ask you how are there any other kinds of water pollution that would be associated with runoff besides total nitrogen, total phosphorus, and suspended solids?
None that were in the scope of the typical review based on the standards associated with the DEP review of the water quality standards.
Is that sufficient for Churchill? I mean, does the heavily used traffic areas have a lot of petroleum products released and metals? Are those to be ignored?
We did not create the standard. We are just reviewing it based on the standard that currently exists.
The DEP spreadsheet is geared to eutrophication. The borough specifies water pollution, which includes toxics, and is greater than eutrophication. So I don't really, I guess I can't agree with you. Well, let me move on. The PADEP wrote a letter citing 131 serious technical deficiencies with the Langen stormwater submission. Can you explain to me how Gateway came to approve the plan with all these technical deficiencies unanswered?
It is typical that a permit, and as is stated within our comments, that a permit would not be obtained at this point. And at this stage in conditional use, oftentimes a permit is not even applied for, as conditional use is typically a prerequisite of even submitting that permit. So that is typical for there to be conditions associated with that. And as we have stated, there are a number of conditions that would still remain to be understood as part of the land development process. And that is typical for any process if it were to continue to that point.
So you're telling me that the hydrologic plan does not really have to work for Gateway to sign off on it and say it's fine?
As with any study, we do have to review it and make a determination in terms of whether or not they could adequately mitigate impacts created. And based on the information that was provided, we believe that they can do that, contingent upon meeting those requirements of the permits. The permits would need to be completed and submitted and correct. And then also they will need to meet the requirements of land development, which would be a more detailed determination of how those would work. If the condition or if the proposed mitigation efforts that are proposed at this point have to change, then they would need to show that they can still meet the requirements that they have shown currently.
They would have to show that they can meet the requirements that they have shown currently.
Correct. If something were to change, if the plan were to change, as we are just in the conditional use phase of the process right now, oftentimes throughout permitting or the land development phase, there may be changes to the plans. If there's a change to the plan, the applicant will need to show that they can still meet the standards that their studies have shown that they would meet at this time.
Okay, it's a little circular. I'm having trouble digesting it. So you're telling me that at some point in the future there will be binding requirements on the applicant that will make the plan work. So, for instance, the PADEP said that you can't have those underground storage tanks without a drainage system. Does that mean that will be a binding constraint on the new design?
Yes, the applicant would be required to meet all requirements as set forth by the DEP, as well as any requirements that we may call out or conditions or comments that we may provide during the land development process as you get further along the process. If it were to get there, there has been no plan that has been approved to this point.
Okay, I'm going to let you off the hook, Mr. Flynn, and I wanted to ask a question about the air study.
All right, so Dr. Casman, we are at 10 o'clock right now. So before we bring Mr. Fennell up, I think if I want to keep my cool reporters and closed captioners coming back for more, we got to give them another break. So we'll see you about 5-10 minutes, and then we'll finish up for the night. So hang on.
Okay.
Thanks. Alex, let me know when council is ready to go in the chambers there.
Okay.
Thanks.
So we're good to go.
Kim, you ready to go too? Great, thank you. Okay, we'll go back on the record. And before we turn it back over to Dr. Casman, I did want to briefly just mention a potential next date for this hearing. Council, as I understand it, was looking at October 4th, which would take us till right after the workshop meeting. So as we have been doubling up a few times over the past few months, what we would do would be to have the council workshop meeting at its advertised time at 7 o'clock. Plan to have that wrapped up by 8 o'clock, and then reserve 8 to 11 if necessary for what I'm assuming is going to be some additional testimony from Gateway and its sub-consultants. So Alex, if you could just sort of take the temperature of council on that between now and when we finish up here, and then we'll make an official announcement prior to the recessing of this particular hearing. So with that said, Dr. Casman, we'll turn it back over to you.
Thank you. I can't remember who I said was next, so I'll just start with air. Is Mr. Sabato there?
Mr. Sabato is not a representative of Gateway or our review.
Thank you. Okay. Anyway, so Mr. Sabato testified that the parkway would be considered a significant source of PM 2.5. However, the parkway is omitted from the air quality model. How can you justify not including the PM 2.5 emissions from the parkway? Our homes are adjacent to the parkway. Do you believe that only counting the site emissions properly quantifies the project's impact on me and my neighbors?
Mr. Fennell, you may be able to speak to the aptitude or whether or not the applicant did provide information regarding that. But Ms. Casman, again, we did provide our review and determination based on kind of the site impacts and whether or not those impacts would either be mitigated or were considered detrimental impacts, if I'm stating that properly.
I'm sorry.
Go ahead, Mr. Fennell, if you want to clarify on that.
There's the impacts of our background impacts are accounted for by using the monitoring data. In other words, the impacts from the project are estimated and added to the background concentrations.
No, the background, the site emissions are added to the background concentrations, but that does not include the added 300 or more trucks on the parkway going to wherever they go. So those are unaccounted for, and it's not the background. They don't become background when they enter the parkway either. They are only there because of the warehouse, and they are a new source of emissions that are not quantified in the impact study.
Remember, Dr. Casman, you have to ask questions. You can't just make arguments.
Oh, my question was, do you believe that counting only the site emissions properly quantifies the project's impact on me and my neighbors?
Okay. The emissions from the trucks are accounted for when they're on the nearby roadways, and when they are on the distribution center. It is true that the trucks driving on the highway are not included in the modeling.
Right, and that's the major route for the trucks because they're not allowed on the smaller roads. So the major, all the the important part of the PM 2.5 problem, mobile sources, is omitted from the study. I think you're agreeing.
Mr. Fennell, correct me if I'm wrong, but the trucks are already accounted for and are not accounted for twice. At least that is my understanding. They're not accounted for again once they are on the parkway. They're accounted for when they are closest to homes or the community. Is that correct?
Yes, the roads in the neighborhood, and when they are in the distribution center, they are counted there. There's no attempt to model traffic on the highway.
Right, which is a problem because of the emissions from the highway. But that's not a question. I apologize. I have a question about the traffic study as well. So the traffic plan says that no crash mitigation will be necessary. Can you outline the crash analysis method?
So I will defer to Michael Haberman, who is our traffic engineer. I am looking for him. It looks like he may have dropped out of, Alex, if you could help me with that, if he may have dropped out of the panelists.
I'm here, Denny.
Oh, okay. Hey there, Mike.
How are you?
Hi, thanks.
Ms. Casman, could you repeat the question, please?
Will you please outline the crash analysis method whereby you concluded, or your there was a conclusion that no crash mitigation is necessary for the project, and I'm asking, what is the method that was used to come to that conclusion?
So that was something that was included in the studies that Langen had prepared, and the analysis, a crash analysis that's performed is an evaluation of crash history at the study intersections over the past 5 years of report that they have data available. In the evaluation, they look at the types of crashes that occurred, when they occurred, the causation, if available, and ultimately look at the crash frequency rates that would be expected for a similar type of an intersection or a similar type of area. So for example, at signalized intersections, you can expect rear end collisions at a particular rate, depending on the volume of traffic and the typology of the road. So they're evaluating, is there anything above what would be expected in these study areas and at these intersections? And if so, would there be something that can be done to mitigate it? So for example, if you had an intersection that had a whole lot of angle crashes with a vehicle, say, turning left, yielding to oncoming traffic, and there are a high number of angle accidents as a result of that, a mitigation for that would be to remove the permitted movement for a left turn, make it protected. So you're looking at all of the different factors associated with to determine if there's an existing crash deficiency or an existing problem that can be mitigated. In this particular case, when the data was reviewed, there were no frequency of crashes or types of crashes at the intersections that would lead a traffic engineer to conclude that there's an existing problem.
Right. So I have two questions. One is, so they only looked at intersections, is that correct?
Correct.
And
I should rephrase that. When you request crash data for an intersection, the data is several hundred feet on the approaches to the intersection as the way that it breaks down. So you could have a crash that occurred, a rear end crash that occurred 300 feet from a signalized intersection that was a result of the cue from that intersection. So that's in the data as well. It's not just occurring in the middle of the intersection. So it's several hundred feet on each approach and into the intersection.
And so they only look at historic crashes, but make no projections of the impact of adding 1,500 employee vehicles and 370 trucks per day. Is that correct?
That's correct. That's correct. And there is no methodology or way to anticipate or estimate crashes based on an increase in volume. If there is a crash pattern that's identifiable now as a result of some deficiency, it would have reared its head in the data. It was exclusive of how much traffic's out there, or when the traffic's out there, or the type of traffic. So if there were going to be a traffic problem, it would exist, or a crash problem, it would exist today because of some signal deficiency or geometric deficiency or some other type of a deficiency. And just by adding traffic to an intersection does not necessarily increase frequency in crashes or change the types of crashes.
Can I share my screen, or is that against the rules?
You can share your screen, Dr. Casman, to help you ask a question.
Well, this is the PennDOT Churchill crash data, and it shows a lot of places with. It looks to me like there are serious problems, and I just can't. Can you reconcile your statement that there's no need to mitigate the crash problems in Churchill, given that there will be so much more traffic there after the project is built?
So I would need some context on the exhibit that you're showing here, as far as.
Sure. This is the PADO PennDOT. This is 5 years of the last is 2016 to 2020 crashes. The blues are vehicles, the greens are property crashes, and the yellows are unknown. But it shows a pattern of, Beulah Road has a lot of crash problems. Rodi Road has crash problems. The Parkway has a lot of crash problems. Beulah is, not only the intersections that were studied has crash problems. looking at this exhibit, would you say that the conclusions of the traffic study are correct?
I think they're mutually exclusive comments. The traffic study results and the recommended mitigations are mutually exclusive from this exhibit you're showing, which was beyond the scope of what was evaluated in the study. It looks like a whole lot of it is along the parkway, which was not part of the study.
But you keep saying, you keep claiming should have been.
Dr. Casman, you need to wait till he finishes his question, finishes his answer. Remember, we have a court reporter.
Yes.
I believe I was complete.
Well, I'm going to stop sharing my screen and move on.
Mr. Rob, can I ask that there be some like level of clarity of question regarding, what Gateway specifically did, as opposed to just ask generalized questions? I know the testimony that was offered dealt with, Gateway reviewing a traffic study and, Gateway making a determination regarding the sufficiency of that. And I think the question should be focused on that because that's what Gateway testified to here today.
I think that's fair, Mr. Ayob, but at the same time, I do want to work with the pro se, the pro se objectors who maybe aren't as familiar with kind of scope of questioning. So I think that's a fair point to make, Dr. Casman, and other questioners, if you have them, that really your questions really need to relate to what Gateway did in this particular instance, the reviewing the data that was provided to them, applying the standards, et cetera. So, and if you don't agree with them, as we've kind of learned through the first 9 days of this, you just have to move on to the next question. That's just how this works. So, Dr. Casman, with that in mind, we'll turn it back over to you.
Okay. I have some questions about the light study. So the original site plan called for lowering the top of the hill by 20 feet. And we were shown balloon studies showing that the visibility of the warehouse would be the same as the current buildings. Was the light study performed using this assumption?
I may be able to speak to that in terms of the general site development that was provided, and Mr. White, you can kind of clarify specific to the lighting study. I believe that the final result was reducing the elevation by 15 to 25 feet, depending on the exact location. The light standards will be placed at that at ground level and will be 24 feet or in accordance with the code from that level. And Mr. White, if you'd like to expound on
yeah,
that.
the light study was based on the current plan elevations for it. So whatever the current site plan shows for an elevation, that's what the site.
Is there a date for when that was performed?
There was a revised one done I know it was between January and March 31st. I don't have an exact date.
That's close enough. So Langen's Carly Davis testified that the plan to lower the site by 20 feet had been abandoned. Does that mean that the light study used the wrong height?
The light study was provided by Langen, and it was based on the current elevation of the site.
It was based on the January to March plan, and her testimony was in August. So it's very possible. Well, I have no evidence.
Her testimony was August 2021. It was after those dates.
Right, exactly. So she said the current plan does not lower the site by 20 feet.
Okay.
So, okay, but the light study is assumes that the site is lowered by 20 feet. So my question is, was the light study performed with the wrong assumption?
I'm going to have to go back and look at it. From my understanding, it was the report dated October 26 is the one that we reviewed.
Okay.
And that was based on the 317 drawings.
Correct. Yes. Yep.
Right.
It says all drawings are dated 3/17/2021.
Exactly. So the plan has changed. The light plan is no longer current, is my conclusion. So I have just a general question about lighting. The operation of a warehouse involves vehicles with lights, vehicles with headlights. Could they impact the residential properties?
They could.
Should that be included in a lighting impact, or?
It was not included.
Okay, thank you. I'm going to surrender the floor to April Kline.
Thank you, Dr. Casman. Ms. Kline, are you with us by Zoom, or are we moving you over to phone? You are muted now if you're trying to use Zoom. We'll give you a couple minutes here. Alex, are you able to help get April teed up?
Gavin, can you hear me now?
I can hear you now. Thank you, Ms. Kline.
Thank you. It's been a long evening, so I've been trying to go through my questions and cross off ones that other people have answered. So, you know, I'm a private objector, and I'm not an engineer or a technical engineer or technical person. So I'm a little bit confused about the gateway testimony. So Mr. Ayob led Dennis through the zoning code conditional use criteria, specifically for a distribution center. But he didn't address any of the general conditional use criteria that's in section 304-31. So does that mean I can't ask questions about the general conditional use, just the specific distribution center criteria that Mr. Ayob asked Mr. Flynn about? Is that correct?
I would say that there is some overlap, recognizing that some of the things that are in the general criteria are covered by studies that Gateway did review. So to the extent that, and again, the difference here, or at least the difference as we're kind of interpreting the ordinance here, is that there are certain items that required input from the borough engineer that are right straight out of the code. The general criteria do not, it's not the same for the general criteria, but to the extent that your question, relates to one of the studies, I think it's fair to ask.
Okay.
That is correct, Gavin. I want to be clear. Gateway has no responsibility under the zoning code to offer any type of input regarding the general criteria. And they only offered any testimony tonight because the borough required it pursuant to the requirements of the specific criteria under the zoning code. So to ask Gateway general questions if they're not specifically related to one of the studies that Gateway reviewed and offered testimony on, I think would be outside of not only the scope of their testimony tonight, but their responsibility to the borough under the ordinance.
Yeah,
Okay.
I do agree with that, Ms. Kline. So if you could try, in that context, if you do have questions, we certainly will hear them.
Okay, and then just to clarify for myself, because it's been a long evening. So Gateway reviewed the studies that Langen did and submitted on Churchill Creek LLC's behalf. And the original permit applications were in December 2020. And by January of 2021, the Pennsylvania Department of Environmental Protection identified some errors and some deficiencies in the original application. And then there was some extensions and deadlines where the applicant had an opportunity to update their studies. So one of my questions was, and maybe this comes under land use and not under conditional use. So Gateway reviewed the studies for the borough, and then in July of this year, they signed off. I don't know if it's signed off or approved is the right word, and then our planning commission took Gateway's advice and they voted to approve conditional use, and now it goes to Churchill Council. So some of us as independent objectors have brought in our own experts, and we happen to disagree with the studies that Langen did and that Gateway signed off on. So I guess I'm concerned on a few things. The traffic impact study, it was noted tonight that the study was submitted and considered adequate, but that doesn't mean that's approved by Borough Council. And I'm really concerned, and some people have references, that the traffic impact study did not include traffic on the Parkway East on 376, and because that wasn't part of the scope, that down the road influenced the other studies. So I wanted to ask Mr. Flynn, do you think that the Parkway East traffic should have been part of the scope of the traffic impact study? Or is that, or you just can't comment on that because that information wasn't provided by Langen?
Hi, Ms. Kline. I think I would like to just state that we did not sign off, and I know that that's just the terminology that you're using. We did just review the studies that were presented to us. And I believe Mr. Haberman can speak a little bit more to that in regards to the process associated with the scoping associated with the traffic impact study and what was identified within that impact study.
Well, that would be helpful.
You're muted right now, Mike.
No, I'm not. At the beginning of the process, the applicant is required to schedule and attend a EIS scoping meeting with PennDOT and the municipality, wherever it happens to be for any type of development. In this particular case.
Excuse me, I'm sorry to interrupt, but I'm going to object to the question on the basis that it isn't relevant at all. I believe that the scoping meeting and the scoping process is an element of procuring a highway occupancy permit from PennDOT. And incidentally, that may have been the basis upon which the traffic study that was submitted on behalf of the applicant was developed, but it's not part of the conditional use process. So I don't see any relevance to explaining the highway occupancy approval process before PennDOT in connection with this conditional use application.
So, Mr. Ferguson, I think, as you know, we're not bound by the rules of evidence. We certainly learned that over the past, nine sets of hearings. And if the question from Ms. Kline is, well, geez, how did you come up with what was going to be, studied for traffic impact purposes? And when you have conditional use criteria that specifically requires a traffic impact study. I'm not sure I understand the relevance argument, but I'll certainly note that for the record, and we'll overrule it. And Mr. Haberman, you can continue.
The answer to the question is that the traffic TIS scoping meeting is held at the beginning of the process with borough representatives, PennDOT representatives, developer representatives, in this case, Allegheny County representatives, because Greensburg Pike is a county road, and then any other representatives. So the reason for that is PennDOT created some criteria years ago in their publications that requires this to be the first step of the process. Because prior to that, municipalities were requiring scopes for traffic studies that were different than what PennDOT was requiring, and then there were ultimately we had cases where you had two different traffic studies done with two different scopes, and it made it very difficult for all of the agencies to coordinate. So this was discussed in an hours-long IS scoping meeting in November of 2019. There was a lot of discussion about whether or not there needed to be an inclusion of the parkway, and ultimately it was determined by all of the parties and agencies that it wasn't necessary, being that it was an interstate and that no new interchanges were being proposed. We did reserve the right to request it at a later time if something were to change with the site design or something were to change with the proposed access. But to date, it's been consistent with what was scoped at the very beginning.
Okay. So I guess, all right, I understand that. Let me think. So the view from Gateway Engineers basically is they review the studies from Langen, and basically they just report back to council that we've reviewed the studies, so that part of the zoning code has been met, but they don't make. But Gateway is not making any judgment on whether the studies are accurate or adequate or not. Is that correct?
I'll speak to that as an overall review of the studies and the information, the comment letters that were provided to us and that we provided. We do review it based on the quantitative regulatory statutes that do exist, and that was primarily our goal, is to make sure that they did follow current regulations or current standards that exist, and that was the review that we performed and the methodologies in which the applicant came to those conclusions. If that helps answer your question.
Okay, and so then once conditional use is approved, then construction can start. And there was a lot of mention tonight about post-construction testing, but then that's too late, right? Because if conditional use is granted, then you can start taking down trees and doing other site changes. And it won't be until years later, post-construction, that those testing or any other mitigations would be done, correct? So I think we're being asked on a leap of faith here to trust these studies and just trust in the future everything will be okay. So I find, as a non-lawyer, non-technical person, I'm finding this whole process a little bit confusing. But Mr. Flynn, thank you for trying to clarify it for me. I have no other questions.
To respond to those comments just briefly, Ms. Kline, to help clarify in that construction would not necessarily proceed following any type of conditional use approval. If council were to go in that favor, the applicant would still need to follow through with any conditions that are set forth within that and complete their land development approval, as well as any conditions associated with that, including all of the permits and outstanding items. So at this point, conditional use is just whether or not the land use is conditionally approved and meets the conditions as set forth within the ordinance. And Gavin, you may be able to speak to that in a little bit more detail.
Dennis, you trying to take my job? What's the deal? No, that was a good explanation. Absolutely, Ms. Kline. That's Dennis described the process accurately. This is the first step. This is a zoning approval essentially, but this does not authorize, the movement of any dirt or, presuppose that any permits are going to be obtained or conditions are going to be met. The applicant would be required to meet all the applicable ordinance requirements, including state, federal, and county as applicable, and then have all those permits in hand. Primarily, there could be some, I think it's fair to say generally that the answer is, not until you have land development approval and the third-party permits, that there's nothing going on at the site, or it's very limited.
Can I ask a question, Gavin, based on that? This is Alex.
Sure,
Nothing prevents the landowner currently from removing a tree or from beginning to take those buildings down if they applied, for example, for building removal permit, for demolition permit, but we don't have a tree removal permit for private property. So I want to be clear at the distinction we're making. There's a land development, obviously, to begin to demolish and excavate and install utilities. That's something. But a property owner in Churchill Borough would have to apply for a demolition permit, and that demolition permit doesn't require, for example, a zoning approval of this nature. Or am I confusing matters?
I don't
think you're.
Can we move? I don't think this has anything to do with our conditional use hearing. It's kind of a Q&A question.
Well, I think it's important because Ms. Kline was making a comment, and we made comments that earth wouldn't move. And we made comments that trees wouldn't go down after she made a comment about trees. So I just want to be clear about what we're saying for the record.
So, yeah, I mean, Ms. Kline, I don't want to answer questions that you're not asking. Do you have any additional questions for Mr. Flynn?
No, I don't. Thank you.
Okay, thanks. And Alex, you are correct that you need a building permit or a demolition permit to take down a building on the site. That's correct. Okay, and no more questions from Ms. Kline. I do see we have Mr. Spirtes, who has a question for the borough engineer's team. So Alex, if you could go ahead and mute Ms. Kline, we can move on to Mr. Spirtes. Hopefully we can get his questions in before we finish up at 11 o'clock.
Should I start?
Yes, sir. But I think we got some echo. Do you have multiple devices?
My wife also, well, she turned it off. Okay.
I think you're good now.
Yeah, I'm also, I would just like to fully understand what it is that Gateway is doing when Gateway approves a study. So for instance, the conditional use ordinance 755 says in one clause, the applicant shall provide a traffic study establishing that the traffic generated at the site will not have a material negative impact on the neighborhood, which study shall be subject to review and approval by the borough traffic engineer. Applicant shall make any improvements reasonably required to mitigate material impacts on traffic and traffic safety. So I'd like to be clear about what it is to approve the study. So there's a letter on July 2nd from Gateway that says, in our opinion, the proposed development meets all the standards outlined in Ordinance 755, conditional use for distribution center, except for one, the submission of an approved parking study. So again, this is related to sort of questions that previously have asked, but does approval of the Langen study mean that you have independently verified that the inputs to the study are correct?
Okay, I can answer that question specifically. As I have stated, we did review the methodologies as prepared by the applicant. We did not perform our own third-party study. We reviewed the methodologies as provided by the applicant and the studies provided by the applicant, and made determinations based on the applicable regulations that exist.
So, for example, when Mr. Prisk testified that his simulation study for the traffic did not include the seasonal influx, that doesn't make you want to go back and re-examine that study? So he testified that there would be a seasonal influx and that it would last 14 days. Shouldn't that affect whether or not the study is approved?
I will have Mr. Haberman from our office speak specifically to how the traffic impact study is evaluated and the requirements associated with that.
Yeah, the industry standard and traffic study criteria and PennDOT methodology and criteria, you evaluate